Hello, everybody. Hello, Manny. Good to see you. Hello, Jerry Matthew Boyd. Hello, Auntie M and Sir Philip. Hi. Hi. How about some Blue Buffalo? You're so darn cute. Billy, you're so in the way. All right. And I know Earl's gonna be going for his. I get a little bit out for Earl. Toss him over there. You want the last one? Of course you do. Oh my gosh. Oh, so jealous. It's currently negative 31 degrees Fahrenheit here. Yeah, it is. Yeah, it's very cold. The University of Wisconsin actually shut down classes for today, which is historical. They haven't done that in over 4 years. Thank God they did, though. My daughter was not looking forward to the half-hour walk twice for 2 of her classes. Yeah. Hello, Michelle Moreland. Hello, Joey Bag of Donuts. Oh, Eileen's here. I didn't see her yet. Where's she at? Well, hello, C-Rex. There's you. Hello, Nana Laura. Nope. No, I'm not. I'm still, can't you see? Can't you see the water just raining down on me? Hello, Buzzy Pug. So happy you're here. Hello, Charlie. Hello, Allison. Oh my goodness. That's pretty bad when it's rising and it's still negative. Hello, Fargan Vistage. Oh, give me 1 second here, guys. That's a case I got. I'm still working while I'm working. All right, got it going. I love you so much. Oh, she really does. I I wish I had known about these protein biscuits earlier. And by the way, this stream is not sponsored by Blue Buffalo. Oh my gosh, speaking of which, so I watch a YouTuber streamer, he's called Officer Tatum. Love him. And he has a new bourbon coming out. It's called Verdict. There's 2 flavors, guilty and not guilty. I'm stoked, y'all. Come payday, I am going to pre-order the guilty and the not guilty, even though I don't really drink. But that's besides the point. I want the bottles. I can't wait to show them all to you. Thank you. It's one of my favorites. You're so darn sweet and cute. I love you guys. You guys are far too good to me. I'm adding Mio acai berry energy to my water. It didn't take much. Like when Mio first came out, I had to like just to get it to the right flavor. So I did that with the first dose, with the first bottle I made. Ooh boy. I learned real quick that they improved their product over the years. That was many years ago. It was when they first came out. And you don't need a lot now. It was kind of like after that first one. I had to like take a couple sips and then pour water in, take a couple sips, pour water in, kept trying to dilute it. You know, about the time I got down to here, it was about diluted enough. Oh, Officer Tatum is amazing. He really is. Hey man, it was free. I did a Walmart order and it showed up. There were 3 bottles of it. And you call Walmart and say, "Hey, I got delivered extra stuff with my delivery," and they say, "Keep it." So now I have Mio. I didn't see Eileen and Carlin in here. So that's from Eileen. I'm not going to open it until I see her. Yeah, it's I don't see anything wrong with it. Oh, did she? It didn't pop up. It didn't pop up on my end. So once I see her, she must have done the popping in and then she'll come back. Once I see her, then I'll open it up. I'll get it over here. And Billy missed a couple treats. How on earth did that happen? That never happens. So we're gonna have some fun today, guys. We have all kinds of courts. We got Michigan, we got Texas. You know, we're gonna roam around a little bit. And we have some characters. I had to throw some funny stuff in because the thumbnail case angers me. Like, I'm going to have to restrain myself. It's going to take everything inside of me not to pause it, every other word, and scream about this woman. Everybody loves to see April mad. I think I stuffed her in like, 3 cases down. But yeah, let's get this show on the road and have a good time. Oh, first, hello, Dixie Normus Boner. Oh, did you get out your PAWFURM smashy plate? Yeah, I am working on a possible merch store thing. Hopefully it pans out. Apparently I need more subscribers in order to make merch a thing. Yeah, one company wants me to have 50,000, and I'm like, I don't even know. I don't even know how that's gonna happen. I didn't. Yeah, we designed one. It's a whole thing. It's got the PAWFURM logo on it, and it can sit up on your mantle or, in your lawyer's office or, whatever. Great little gift. And when you get really super, super mad, smash. Hello, Megan. So happy you're here. Yeah, so yeah, and it would come with a little gavel, in case you didn't want to smash, you could gavel smash. And I just knocked my elbow pad off. It's totally in the works. Did you? Okay, thank you. Thank you. It's just not the same without him. All right. Oh, will I? Well, okay, yeah. I can. It's not like I have a stream to run or anything, Jerry. Oh, excuse me.
And those cases just aren't relevant here because again, the
Well, I saw some smart alecky comments in your motions saying that the sophisticated insurance company and their sophisticated counsel are expected to know the law. That seemed to be a little bit unnecessary, don't you think? As far as language goes and presenting to the court.
I mean,
oh, you don't think that's smart alecky? I do. I think it is. I'm going to tell you right now, I don't think that's really appropriate. You don't try to nudge somebody on the opposing side saying, well, they're sophisticated and they're smart and they should know the law. I mean, come on. Let's grow up, shall we?
Sure.
All right, what else? What else do you have?
That's fine, Judge.
Okay, that'll be May 8th, 8:30 a.m. in person.
Your Honor, I do have some requests based on that.
Okay, go ahead.
Yes, my client is currently living out of state. He's always lived out of state. This is a allegation that this communication was done through a live stream or a gaming system. So he's never had any contact with the state other than through this alleged contact. He's actually been accepted to a Masters of Arts program in Portugal. He's actually delaying his departure date to Portugal due to this this case. I did tell them that this court does not normally allow Zoom trials or Zoom jury trials to occur, but he is out of state and he does not have the financial resources to be back in the state. So I'm asking that this be allowed by Zoom.
Okay. I don't have an issue. Is he testifying?
Yes, he would need to testify, Your Honor. It's a he said, she said case.
So I require testimony in person is my concern. Mr.
Yeah,
Tomlinson?
me too.
If he wasn't going to testify, like I would say,
Right. If it was a
fine.
bench trial, I was fine with that, but now that we're.
Yeah, and I need him here for a jury. I think that May is enough time for him to figure that out. I need him actually here for a jury. Number one, if we're bringing in a jury, he needs to physically be here. I could do a bench trial, but even then, my issue with that, it's a practical issue. It's not, I mean, you guys know, I don't care if people are in here, not in here. Testimony, I always require in person for purposes of I don't feel I can properly preserve it if they're not right here because so much can be going on behind a camera. But you can't even talk to your defendant during a trial if you're here and he's on Zoom.
That's correct, Your Honor.
So that's difficult. Even if you're both on Zoom, I can't have you talking and communicating to each other during a trial, which a lot of times is needed. When you're holding a trial, it's beneficial for you as the attorney to be able to communicate with your client, but also to bring in a jury and not have him here. I mean, I'll move the Fridays, but he's got to find a day he can come here.
Mr. Luderman, is May 8th enough time? I mean, that's like almost 3 months away. Is that enough time to arrange for transportation?
Well, the thing is, I'll be in the middle of a course, and out of a, you know, I'd have to literally leave my master's degree and stop that just because it's
Do
something
you want
that
to do it
somebody.
in June?
who-
I mean, you're going to have,
the thing
sir,
is,
you're going to
ma'am,
have to give
the
me
thing
a
is,
Friday
ma'am,
you can come.
I don't know if you've seen any of the evidence I've submitted to the court, but this
No,
is
I don't
all
get to review.
because.
Mr.
Sir,
Luderman, we
stop.
can't talk
Oh,
about
okay.
this.
Sir, I don't
Okay.
get to review evidence before you come into court for a trial, but I am telling you, I am requiring you to make some time to come here. I realize it's inconvenient
Uh-oh,
in your
you
life.
cut
It's
out your what?
inconvenient
Sorry?
in most people's lives to come here.
Sorry,
I am allowing
you
you
cut
a
out for a
3-month
second.
notice.
Yeah.
What?
Well, your voice cut out for a little bit. I couldn't hear. I'm allowing, and then it cut out for.
I'm requiring you to come in person. So give me a Friday. I understand it's inconvenient. There is no reason you can't take one Friday to travel here.
Does
We
May
do them on
8th
the
date
second
work,
Friday of the month.
Mr.
You can
Luderman?
have May 8th or June 12th. You want to go into June, we'll go into June, but you're coming in person and this is not negotiable. I mean, it inconveniences most people's life when they have to come here, but that's something we have to live with sometimes.
Right.
So you can come on June
Well,
12th.
how would we be able to do it? So I guess if it wasn't going to be in person, is there another way of doing this where
No,
it's not
Mr.
in
Luderman, it has to
person?
be in person.
No,
So either you have
has
to
if
to
pick
you
be.
May
want
8th,
trial,
May 8th
you
or
have to
June
come in
12th.
person. I ask for very little of people. If you want a trial,
Okay.
you need to actually give me the time of day to show up here.
Mhm.
And I
Wow,
get what
okay.
it's like to be in a master's program. Guess what? All of us here are very educated and
Oh,
have had
yes.
to maneuver
Yes,
stuff
I love
around
that. I love
education
that.
requirements
Yes,
and
ma'am.
school. So we've been
Yes,
there.
ma'am.
You
I
can't
love
tell me you can't give
education.
me a Friday.
Yeah, it's just it's because I would be in a different country. I don't know if you understand that. It's not like I'm coming from this the same state or a different state.
I
I'll
understand,
be
but
in
I'm
a
letting
different
you have
country
months'
then.
notice.
Dude, she's giving you till May or June, your choice. And you can't make arrangements for a trial that you want to have to clear your name. And you're acting like you're so much more important. It's not going to go away on its own. This is the process.
So June, I mean, you can have June. I'm not saying you have to come here next week.
Right?
You need to pick a date, Mr. Luderman, or otherwise the court's going to assign one.
Okay.
that is true.
Okay, and what's the, so June you're saying?
Either May
June
8th or
12th.
June 12th.
Pick one.
I guess, May 8th.
Very well.
All right, May 8th at 8:30 a.m. I'll see you in the building in person. We'll go from there. Thank you, Mr. Becker.
Okay,
Thank you.
and,
And
and
get you
in
the
the
no
case I
contact
do need
order.
to change this, in the
Then you
case
need
that
to
I
call
do
your
need to
attorney.
change the
Mr.
date?
Becker will
Okay.
contact us. You don't contact us. Mr. Becker can contact
Perfect.
us.
Okay, I contact him and he would be able to. Okay, thank you very much.
And to be clear, you cannot have contact
Yes.
with the complainant.
Oh, okay. And the complainant entered a party of mine in the video game without me
Mr.
inviting her, and then she was saying all of these things
Doesn't
to me.
matter. You need
So-
to walk
so what
away.
happens-
You no. The no
Oh,
contact.
so
The
I
only
need to,
person I have
so if
jurisdiction
she
on
joins
is
my
you.
party, I have to walk away.
You
Yes.
have to walk away. You're the only person I have jurisdiction over. Stay away from the complainant. You walk into, she walks into somewhere you are, you walk away and leave. That is on you. You choose to stay,
Right.
then you are
This
violating
is,
the no contact.
So quick question. So if I'm in a video game, I'm not supposed to be in that video game?
Mr. Luderman, she's saying if
If-
the complaining witness shows up into the video game, then you need to disconnect. You cannot have any
No, my
contact with
question
her.
is, because that's literally why the reason that she's doing this is to keep me off a video game.
So, Mr.
This
Luderman,
is
I'm
the
not
reason-
gonna do this back and forth with you right now.
Right.
If she comes
Oh,
into the
I'm
video
just
game,
wondering
get
to
out of the video
understand so I
game.
can-
Because Mr. Luderman, and I'm gonna be real direct right now, your option is to do this way and remove yourself from any potential situation that could harm you, which is what I'm advising you do. If she shows up, you walk away.
Right.
I don't have jurisdiction over her.
So,
However,
okay, well, my question
if
is
you
this, ma'am.
want to if you want to decide that you're gonna stay because she walked into your space on your video game and you're gonna stay, and there's a violation, I have every right to issue a warrant for your arrest, and I don't want to do
Okay,
that.
but ma'am,
So
what
you
I'm
need to
asking you
continue
is
in your
this.
master's program. You're gonna come to me in May, and you're gonna stay away
Right.
from her. And if she enters a video game
Right.
room, you're gonna get out of it because you can't have contact
This
with
is-
each other.
But this is my
don't
question.
wanna
The video
debate
game
it.
room
It's not a
doesn't have
debate.
contact? That's
I'm
not a
not
debate. I'm
debating this
I'm
with
trying to understand you, ma'am, because there's two different things. She entered my chat and there's a game. The game is one thing, the chat is a different thing. The chat is something that I can leave, but I don't understand why I would have to leave the game if there's no chat in there involved and there's just a video game.
GameStop. Video game is life.
Just don't have contact with her.
No, yeah, I definitely don't want to have contact with her. She joined me, my party, and I'd have kicked her as soon as she did.
Okay, then that's fine. Don't have contact with her. It's not
Thank
that
you.
hard. It's
Thank
not
you,
a
Your
hard
Honor.
debate.
And if
Have a
she
good
tries to
day.
have contact with me, do I contact my lawyer about it?
Yes, you do. It's exactly what
Okay.
you do.
Perfect. And then you guys can do the same thing to her if she does contact me, though, right?
No, I have no jurisdiction over her. She's not charged with anything. So
Okay.
the only person
So she can
responsible
just-
for
she can
whether or not
continue
you
to
guys have
harass
any
me.
contact is you. If she puts herself in a place
Okay.
to have contact with you, it's up to you to negate that and walk
Because
away.
she started this harassment 4 years ago. That's the proof that I submitted to the court.
Sir, I'm not debating this and I'm not holding a trial right here. We are
Perfect.
done.
Thank you
okay?
very much. I
Thank you.
appreciate you.
Please disconnect.
Thank you, Your Honor.
It's a requirement, isn't it? Yes, absolutely.
All rise, district court two is now in session, the Honorable Judge Bruce Canty presiding.
Good morning, thank you. You may be seated. Is that Dawkins? Are you Dawkins?
Yes, sir.
Hang on a second, Dawkins. You don't have to say anything. I'm gonna look at some stuff and ask you some questions. What are you shifting the topic? We were just talking, you can have a seat. We were just talking about, I'm not asking you to leave, but actually the county has rules that you can't bring a dog into a place unless it's been cleared as a service animal. Did you know that?
I'm sorry, I told her.
I know that. I know that. I'm just telling you. I just attended the meeting this morning where they explained this to me.
Oh,
Really?
Yeah, so if somebody brings a dog into a county facility, we have to call the county, the courthouse, and you have to commence the procedure of getting it cleared as a service animal. I didn't know that either.
Something tells me that that might violate ADA laws. Go on, Washington State.
Works as a service animal, she's
I'm
not
just-
registered. one.
I'm just saying, it's the world of government. All right, hang on here.
I think I'd want her service animal.
A ticket on 30361. Duty on striking an unattended car. Now, what that's called is hit and run unattended. It means you hit or damage some property and you didn't do what you were supposed to do to follow. You don't have to. I'm not accusing you, and I'm not asking you to answer. I'm just telling you that's what the ticket's about.
Yep.
And then, so that was January 4th, and it said, get here today at 9:30, which you did. Is your address, trailer 21? So that's where, if we had to send you a summons, that's where you'd get mail.
Came by there.
We want to make sure and do that, because
Yeah,
we don't want to have to issue a warrant for you.
yeah, I know, I'm sorry about.
Yes, ma'am.
That's not, our mailing address.
What is your mailing address?
It's Post Office Box Beaver.
In Beaver?
Yes.
That little Beaver post office is still open?
Yep.
Yeah,
She's still there.
I'll be darned.
door's a little rattly, but. door's a little-
Did you know you have 2 warrants?
Yeah, I know. I got, in Spokane and stuff.
Actually, you have 3 warrants. So what are you doing walking around with warrants that you haven't taken care of?
Well, they're in Spokane, and I'm not planning on going back there too much.
What do you think they are? Do you think they're probation warrants or something? What are
Yeah,
they?
probation, violating a restraining order. It's bullshitting my, I mean, with my niece. I had to kick her out of my van because she kept like stealing from me and doing drugs and running off.
Oh, I know, but I mean, that's so,
I was living.
well, but just hang on a second there, Dawkins. Technically, it makes you a flight risk, which isn't a good thing, because
I'm not, I'm here.
well, I know, but I'm just telling you, from a judge's point of view, I'd have to put a bail on you. That's what we're trying to avoid warrants, and we're trying to avoid bail.
Yeah, well.
Well, like the way it is right now, I could actually put a bail on you. Speaking of which, what's your income?
My income is Social Security,
Okay. Retirement or disability?
retirement and disability.
Gotcha. So what you're
Yeah, I
saying,
get-
so
I
what you're
moved-
saying is you're not Jed Clampett.
Pardon me?
You're not Jed Clampett. You can't write any big
No.
checks.
Heck no.
So you can't afford to have a bail on you, can you?
I live in a small trailer in a trailer park.
Right.
No, I can't.
All right. Well,
I'll be here. I
well,
wanna
you
get-
gotta be, because based on you having 3 warrants,
Yeah, I know.
but what I'm telling you is, normally, if I was in my normal kind of mood, I'd require you to post $1,000 cash. You got $1,000?
No.
Well, see, that's what we're talking about. So you got to get to court on time. We're going to appoint Clallam Public Defenders to represent you. I found probable cause for striking an unattended car or other property and then not sticking around taking care of business like you were supposed to, which is not a good idea.
No.
That's maximum punishment is 90 days in jail and a $1,000 fine. He signed his advice of rights. We've appointed him a lawyer. So among your conditions of release, Mr. Dawkins, you can't have any new violations of the law. If you hit some other property with your car or something, you just need to stay put until the police, you don't have any business running any risks of getting arrested again. Report back to court as directed. So we're talking 2 weeks from now, aren't we? What day are we talking?
February 2nd.
You're coming back here February 2nd. So is your license okay? You got a good license?
Yep.
Okay, well, you or your wife get you here in person. I want you here in person on February 2nd at 1:30. Isn't it a Forks ticket? Yeah, 1:30. You're gonna be back here on 1:30 on the 2nd of February.
I
Now.
appreciate this, Your Honor.
Did you know any of those people involved? Do they live down there in your trailer court or anything?
No.
The car you hit, you don't know them? Because technically you wouldn't have contact with them. Tina Brown is the registered owner of the vehicle. We're gonna say you can't have contact with her, but I'm assuming you wouldn't know how to find her anyway, would you?
I'm
That's
Tina
Tina Brown
Brown.
right there.
What's that? Oh, I see. Oh, that's your car.
Yes,
That's your car.
yes.
They live together.
You're two. How come you look familiar? Did you go to school around here?
I'm from Utah.
Okay, so you just look
I've only
familiar.
been here since 2010.
Gotcha. All right, well, I've seen you somewhere, I swear.
I used to live out there in Beaver by Judge Doherty.
Oh, you did?
Yeah.
Did he complain about you? I'm just teasing.
Oh, him and I got into it a couple of times, my landlord.
Now, you see, I'm not totally surprised.
But no, I've never been in this place.
Well, never mind. I don't see the owner of a vehicle. We'll just cross that out. We're gonna cross out. We'll let the prosecutor, we'll let Rod Fleck, Mr. Fleck figure that out when we get back to court. So anyway, you can't drive unless you're properly licensed, no new criminal conduct. So those are gonna be your conditions of release. Need you back here in person on the 2nd at 1:30. You understand all that?
Yep.
And, I don't know what you're gonna do about those warrants, but I'll tell you, if you miss court, I gotta require $1,000 cash for you to post bail. Cause you got 3 warrants. I could have put bail on you today, but I didn't because you're old and I don't think you're gonna cause me any trouble.
Yeah,
I'm
it
old
was just
too.
forgetfulness. I was gonna go back there and talk to him and then things got, and I just,
Well, it's a long ways over.
yeah, and I wasn't even sure what I hit, man. I mean, when I,
Oh, no, you don't want to talk about your case right now. You tell your attorney, you tell your attorney about that.
I'm guilty.
You tell your attorney about that and then we'll see you on the 2nd at 1:30, okay?
Okay, sure.
I need you to come up and sign it.
Oh, another little thing about the dog. One of the reasons why the county is stickler about that is some people have allergies.
Yeah.
So like you come back here on the 2nd, if somebody has an allergy, then I gotta kick you out.
I gotta get your dog shot.
What? I never thought of that till this morning. They were just talking.
The dog is his service animal.
Actually, according to the ADA, allergies don't trump the need of a service animal, a true, actual service animal. One that is trained to perform a duty like monitor blood sugar, seizures, heart attack. You know, those kind of come before allergies.
Well, I know that, but the thing is,
Yeah.
the county says we gotta clear it through them first. And I'm just letting you know, if somebody says I'm allergic to dogs, you're out of here.
Person posting bail.
So.
No, you're supposed to sign here.
I'm sorry.
I'm sorry, no, I pointed the wrong place.
No, I feel look a little better.
My vehicle,
Yeah, or leave them in the car.
we can't leave her in the car.
Now, why is that? Why is that?
Because Collin County will take it if I leave her in the car.
You guys got a lot of problems you shouldn't have.
Yeah, that's for sure.
You got a lot of problems you shouldn't have. All
Yeah.
right, you guys, we'll see you on the 2nd at 9:30, okay?
I can leave her home and she can terrorize the poor cat.
Don't terrorize the cats.
I'm gonna give you a copy I made. Out your sooner because it doesn't want to
I'll
cooperate.
make all my court dates. I promise.
Yeah, you need to be here for that. You bet.
It's, you'll meet your attorney. He should be here on that date. Okay,
Mhm.
you're all set.
Dang it. Oh, I didn't even sign.
Thank you. You have a good day.
Sorry about things, miscommunication.
I just want to pay for it.
This is Judge Eric Shepard presiding in Travis County Court of Law Number 2. I'm calling this hearing to order in cause number C1CV2400397.
Get ready, guys. I'm going to do my very, very best to keep my mouth shut. But I cannot shut my face up.
Jashina Medalis as next friend of AG, a minor, versus Jess Michael Foltz. The date is Thursday, January 22nd, 2026. This hearing is being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted other than by the official court reporter. Any violations of these instructions are punishable by contempt of court. If you would announce yourself for the record, tell me who you represent, and if you're asking the questions today.
This is Sarah Levy. I'm here for the defendant in this
Okay.
case.
All right.
I'm Erica Hansen, on behalf of plaintiff.
Okay.
I'm Carrie Ward. I am standing in for Jesus Cifuentes, who is the guardian ad litem in this case.
All right, Ms. Ward, are you asking the questions?
Oh, I am not. I apologize.
Okay. Ms. Hanson, are you asking the questions?
I guess I am. I thought that was going to be the guardian ad litem. But if that is something that I need to do, then I will, I didn't know that I would not be here, but I can take that on.
Mr. Metellus, if you could raise your right hand. You solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, thank you. Go ahead, ma'am.
Thank you. Ms. Metellus, can you please introduce yourself to the court and tell us how you are related to Aliyah Galoob?
I am Aaliyah's mom.
And what is Aliyah's date of birth?
06/02/2020.
How old is she now?
She is 5 years old.
Back on November 6th of 2023, was Aliyah injured in a motor vehicle collision?
She wasn't injured, but she was in the vehicle.
Would you say that she was shooken up?
She was.
And how old was she at that time?
I'm gonna say she was 3. Yes, she was 3. Because this has been over 2 years now, going on 2 years. So.
And is that a collision that occurred at the intersection of 1622 and Manchaca?
Yes, right across from the phone repair.
Fair to say the facts of that are that there was a vehicle coming from the right that hit the front of the vehicle that you and your daughter were driving in. Is that correct?
Yes, I was in the left lane. The light was red, waiting for the light to turn green. The car came out of nowhere from the right side, coming out of the little plaza on the side. And instead of like going slow and looking each time, because it's about 3 lanes before you could get to the other side, he just went straight and I was the one sitting there. So, and he hit the front of the car.
Following that motor vehicle collision, did you retain legal representation to represent you and your daughter in pending litigation?
Yes, I gave you guys a call.
And you're aware that the case has settled with Progressive, who was the insurance company in this suit. Is that right?
Yes.
And are you aware of the fact that Progressive made a settlement for Aliyah in the amount of $6,000 total?
No, I mean, I am not aware of that.
Okay, is that not the settlement memo that you signed back last January?
No, the amount that you told me, even the day of the last court date that did not end up following through, was 3,800 and something. I did not know that there was a settlement for 6,000. Or I did not sign a paper with a
Okay,
settlement.
let me back up a little bit. And I think I may have confused you, and I apologize for not being clear in my questioning. Have you and I discussed the net amount that would be paid to your daughter, and that being $3,697.70?
That's the amount that you told me, but you did not give me the full amount. And then, of course, that's the amount that's left over after you guys take your percentage.
Okay, thank you. And so let me clear that up. So that net amount is the amount that would be due to you to your daughter after 3.33% attorney's fee and case handling fees are deducted from the total of the 6,000. It looks like you signed that settlement memo back on, exactly a year ago, January 22nd of 2025, with that net to your daughter being the $3,697.70. Does that sound accurate? Does that ring a bell now that I've explained the numbers that I'm talking about?
I have to go by what you say because when I signed the document, the first time they sent me the document to sign, I didn't sign it because I didn't agree with the amount. Now, the amount that you're talking about, when I signed it, I didn't get to take a screenshot. There was no option for me to save it. So I don't have the final agreement in hand. So I can go ahead and verify the amount that you're saying is correct or not.
Okay.
So
Would it help you if I shared my screen so you can see that?
that would be fine. That would be nice because I
Okay.
don't have the paper myself.
I'm not able to share my screen in this Zoom right now. It looks like I don't have that capability.
It's fine.
Hold on one second. Can you try again, Ms. Henson, and see if it works?
Yes.
There we go.
Okay. Are you able to see my screen now?
Mm-hmm.
Okay. And so there's the 33.33% fee that I referred to. In addition, there are fees for essentially filing the case and handling the case that totaled the $2,302.30. That brings the net due to Aaliyah to $3,697.70. And it looks like that was signed a year ago today. And in preparation of today's hearing, have you had an opportunity to speak to the guardian ad litem?
He has not called me not one time. So
However, I'm not just talking about today's hearing, but in the process of leading up to this hearing, have you had an opportunity to communicate with the guardian ad litem, Mr. Cifuentes?
nope. The only time I messaged him because of the fact that I showed up at the court and you were telling me that he's not there was the only day that I had communications with him. After that day, I have not received a call, a text, an email, or nothing.
Okay, thanks for clarifying that. When I have spoken with you previously, I've described the fact that we're going to have input at this hearing from the guardian ad litem and regarding this settlement and regarding what will be in Aaliyah's best interest. Is that right?
Yes, and I spoke to you the day of the court, and yep.
Okay, and you understand that it is in the judge's discretion to determine what is to be done with that amount, first of all, to order that this settlement is in the best interest of the child, and then also to determine the correct way to handle those funds, which generally go into a trust. Is that correct?
From what we spoke about on the day of that last court date, I would hope that because I did express to you my financial hardship and what's going on at the moment, and you said you would do your best to go ahead and have this resolved. So I'm just listening to see what happens.
Right. And so I believe I expressed to you that the court generally will put funds for a minor into a trust. However, you indicated that you have financial hardships that could potentially even affect things like your housing stability, that affect your ability to just provide basic needs for your child. Is that correct?
Yes.
So you had asked me to advocate on your behalf for at least a portion of the settlement, if not all of it, to not go into a trust, but to be provided to you as Aaliyah's mother and guardian. Is that correct?
Yes, and I did go ahead and inform you that no one informed me, even in the beginning, that whatever Aaliyah would be getting would be going into a trust fund.
Right.
hmm
And you understand it is in the judge's discretion to make that decision. Now you understand that.
I mean, I mean, I would hope that from, because I spoke to you, you're speaking on my behalf. So,
Can you just for purposes of educating the judge, describe a little bit about the financial difficulties that you're facing and why it is that you've asked me to advocate for the court to release those funds to you to provide for Aaliyah?
For one, it's not your money. It is your child's money. It is not for you to pay bills. It is not to make your life easier. And exactly how much did you expect for this payday for a child that was not injured? She was just a little shaken up or shooken up, however you said that. You don't get that money. At least you shouldn't. I don't care what your financial hardships are. You're the mother. It is your job to provide for your child. And you don't get to take her money because you are failing to do so.
okay. For one, I'm a single mother. Aaliyah's father is not in her life. Since the day she was born, 2 weeks, it's been only me and her. I only receive $116.40 every week for her from child support. That's all that I get. I have no communications with her father. I don't know where he is. I don't know what's going on. I am here trying to do my best, but this case has put a burden on me for the length of time that it has taken for the case to get resolved. And plus, without being misinformed every single time. Right now, I'm behind on certain things. I'm behind on my car payment. This coming month, I'm not sure if I'm going to be able to make the full payment for my rent. And that is something I did express to you the day that I went to the court. And yeah, you know, so that's why when you did go ahead and you were telling me certain things, I broke down because, like, you guys are handling the case, but you guys don't know what the person is going through on the other side.
Ms. Metellus, if some or all of the funds were to be agreed by this court to be entrusted to you to care for and to provide for Aaliyah,
Yes.
what would those funds go toward?
It would go towards making sure that I am able to keep this roof over her head, the vehicle that takes her to school and back, providing food. We do have a freeze that's happening pretty soon. I don't know how bad it's going to be. And if I could put some money away for her to save for a rainy day, that too.
Do you believe that it is in your daughter's best interest for this settlement to be approved by the court?
Yes.
Thank you. I'm gonna pass Ms. Metellus at this point if anyone else has questions to ask of her.
I don't have any questions at this time.
All right. The total is 3,600 and what?
$97.70.
Okay, the 1,600, so the 1,600 and change, she could take out immediately. The 2,000 of it basically will stay into the registry of the court. We'll see what happens later if we need part of it, but we can start there and go from there.
Thank you, Your Honor.
How old is the child?
She's 5.
Okay. Yeah, I'm comfortable with that. We can do that, and then, ma'am, you can come back and ask for more if you need to, but that's where we'll start. So that's $1,697 and
$0.70?
70 cents. All right, thanks. Yes.
That's not even.
Thank you.
Oh,
Anything else? I'll need an order, and as soon as I get it, I'll sign that order.
man.
We'll get that to you.
All right.
That.
Thank you very much.
Yeah.
Oh my God.
Yeah. Are we excused?
Yes.
Okay. Thank you, Your Honor.
I can't believe the audacity. That's not your money, lady. Thank God they didn't issue it all directly to you, because you clearly can't manage your finances in a way that you don't have to rely on your now 5-year-old daughter to pay your bills. Oh, that made me so mad. And you could see everyone in the court like cringing.
Okay, here we go.
D-man. And here, Estefo. Okay, let's do Mr. Estefo. Mr. Estefo, this ticket goes back to the 17th of October. And the allegation is that you were parked that day, that you overtime parked. And the picture I'm seeing seems to be in a permit only.
You have virtual meters, would be the alley, south center alley.
Okay. And so the parking ticket here was for parking in the permit area without.
Is that 1947?
No, the ticket ends 0935. This is Mr. Estefo.
Okay.
And the allegation is permit parking. So he photograph shows the car in a permit required area.
Yeah, I
Mr.
have
Estefo, did you have a permit parked there?
Yes, sir. I'm with DoorDash and Uber Eats. I've been here in Royal Oak 5 years, 10 hours to 12 hours a day. This is spot, sir. Special business spot every single day between 50 to 70 to 100.
Can you show me the permit that you had to park there, please?
What's that?
Can you show me the permit that you have that permitted you to park there?
Yes, sir, because we have this.
I asked you to show me something, not to talk.
Okay. 1 second, sir. So, like last.
Would you show me the permit, please?
I will show you the place.
That's the place. I want to see the permit that says you can park there. You said you had a permit. I'd like to see it.
No, no permit. I mean, we are DoorDash and Uber Eats, sir. Let me explain
There's
to you.
nothing special about any business. They have the same rules that private people have.
Okay, sir.
Parking in a public lot, you have to play by the rules of the public.
At last 45 minutes. At last 45 minutes. This is nothing. This is I pick with last 45 minutes 4 picture with 4 driver here. 4 driver. We park there every single day to pick the order and then back right away and run
Mr.
away.
Estifo, repeated violations is not a justification for another violation.
Sir,
If you require if a permit is required for you to park there, the fact that you always park there without a permit doesn't mean
okay, sir.
what you did wasn't a violation of the ordinance.
If you don't mind, I want to tell you something, sir. We are, me and next me, my friend, we park at same spot. He's DoorDash also. He's here at Royal Oak right now. I got a ticket and my friend, he got a ticket.
Okay, then you want the police to give your friend a ticket?
No, sir. I mean, we are parking.
Why are you telling me that?
Because we are parking there every single day, over 100 driver. No one got a ticket except me. Except me, sir. Every single day, morning, afternoon.
You know how many parking tickets I deal with a day? I don't believe that anybody can say that they're the only one that got a parking ticket.
Sir, they have.
Mr. Estifo, a permit is required to park where you parked. You didn't have the permit, you owe the money. It's $50. You can pay it online or by mail, or you can pay it at the courthouse counter. We are done, sir.
Macomb County Jail. Can I have Prasuti, please?
Yes, ma'am. Hey, Prasuti! It is. Right. I have my reasons. You're beautiful. Come in here, talk crap to the judge instead of everybody else.
Oh, Your Honor.
Good morning. 25 RV 4918 people versus Mark Prasuti.
Hello.
Raymond Rumenap on behalf of Mr. Pizzuti. Your Honor, we would waive formal reading and stand mute for purposes of arraignment.
Great. Mr. Prasuti, please state your name for the record.
Mark Edward Prasuti.
Did you talk to Mr. Rumenap today?
Yes, I did, ma'am.
Did he go over your rights with you?
Yes, he did, ma'am.
Did you understand all of those rights?
Yes, I did, ma'am.
Do you have any questions regarding your rights?
No, but I have a statement.
Okay, hold on, sir. We'll get there. I'm going to enter a not guilty plea at this time with regard to the arraignment. All right, with regard to bond, Mr. Amp.
As to bond, Your Honor, Mr. Pizzuti is 55 years old. He was living in a group home. He's been there 6 months. He's been a lifelong Michigan resident. He's currently seeking employment, single, no children. Claims that his only record is 3 DUIs over the years and 1 possession of marijuana. All of them misdemeanors, and one of them would be legal at this point. He is seeking court-appointed counsel. He's asking for a personal bond.
All right. Mr. Prasuti, what did you want to tell me? You cannot talk to me about the case, though.
Okay, I want to tell you, I have 3 job interviews tomorrow between 1 and 2:30. I can't miss them because I'm going to get the jobs.
Well, I have no problem making sure that you get there as long as you promise me you're going to come to court with me. Deal?
I will come to court every time you call, man. Swear to God.
That's all I.
All
you
right,
come to court
so I'm
with
out of
me.
here.
I want you to get to your job.
So
Is
I'm
that
out
a
of
deal?
here.
Well, give me
I outta
1
here?
second. Do you have any other holds?
No.
Okay.
I have a
There is
traffic
an-
ticket if you want to take care of it.
Is it in my court?
Yeah, I don't know. It might be. I don't even drive. I shouldn't have a traffic ticket.
Okay, I can only take care of things that are in this court, sir, but I am
All right.
happy. to do
Don't worry
anything that's
about
here.
it.
What we have here today, though, is I just have this MDOP. I am gonna give you a $1,000 personal bond. I am not gonna make you post any money.
All right.
I'm gonna set it, all right, but it doesn't mean you don't have other holds. I don't know. I just don't know.
I don't.
That's all.
I don't.
Okay, I'm gonna set a pretrial up. Would you like to come in person or on Zoom?
Zoom. How do you do Zoom?
You have to
On
call
your
in to
phone?
me.
Okay, on a cell phone?
Yep.
Okay, I'll do that. Zoom.
If you can't Zoom in, you do need to get yourself into the building. Deal?
Okay, deal.
Okay. All right,
I
Mr.
can Zoom it
Krasuni.
though. Thank you,
You can
sweetheart.
Zoom it. I'm
Ma'am.
gonna give you the option. I'm gonna
All
give you the
right.
option to Zoom it because all I care about is that you get into my court.
Okay,
So
okay.
if you're in here
Okay.
on Zoom or you're in here in person, doesn't matter to me. Deal?
All right. Thank you, ma'am.
All right.
This correction for that file, Your Honor.
Okay.
He's currently living on.
All right, I'm getting out
We're
of
not
here.
gonna place it on the record, but did you do it on the
I'm getting
paperwork?
out of here. Hell yeah.
Yeah, we'll note it there. We just don't want to place it on the record because we go live to YouTube and I just don't like to put people's personal information out, but you're all set. Oh, thank you. Can I have Bailey, please?
Yes, ma'am.
Next, can we have Matucci, please?
Oh, yes, ma'am. Touch.
Mr. Matucci?
Come on, Touch.
Oh, they're on a friendly basis now. Hi, Mr. Matucci. 2682-705 People versus Matucci.
Yes.
Record agreement on behalf of Mr. McKinney. Waiting for reading stamp for purposes of arraignment.
Mr. Matucci, please state your name for the record.
My name is Anthony Arthur Matucci. Your Honor, I committed this crime because I've been doing this 9 years.
No, Mr. Matucci, we're not going to talk about committing crimes right now. We're going to talk about rights. Let's talk about rights.
All right.
Okay. I don't want you to talk about anything about, and I don't want you to say anything about ever committing a crime. We are being recorded.
Okay.
We are live broadcasted to YouTube.
Okay.
Let's protect you. We're going to talk about your rights. Deal?
Okay, gotcha.
Did you talk to Mr. Rumenap today?
Thank you, Your Honor. Thank you. You feel warm-hearted to me. Thank you. Your
Did you
Honor.
talk to Mr. Rumenap today?
Yes, I have.
Did he go over your rights with you?
Yes, he did.
Did you understand all of those rights?
Most of them I did.
Do you have any questions regarding this?
I just wondering if I could get
Just your rights. Do you have any questions regarding your rights?
yes, I was wondering if I could get a personal bond.
I know, but Mr. Matucci, that has nothing to do with your rights. Do you have any questions regarding your rights?
No, I don't.
So do you know all your rights and you have no questions regarding those, or do you need me to go over any of them with you?
No, I don't.
Okay. That's the first thing. I'm going to enter the not guilty at this time. Now we're going to talk about bond. Mr. Rumenap, with regard to bond.
Bond, Your Honor, Mr. Matucci is 56 years old. He's been a lifelong Michigan resident. He's homeless at this point. The street of, there is a prior record of.
I'm going to let you talk, Mr. Matucci. Hold on.
There's a prior record of minor offenses, basically to find housing over the winter months.
This guy crawled straight out of a sitcom, I swear.
I asked for a personal bond and a contact, a referral to, he also wants the court-appointed attorney. But I think the important thing here would be a referral to community services, community correction, so that they could steer him into some kind of a housing, either halfway or three-quarter house would seem to meet his needs. It gets him off the street and ends his purposes here for coming before the court again.
Yeah.
All right, Mr. Vitucci, I have some questions for you. Where are you going to live? It's very cold outside.
Where am I, what, ma'am?
Where are you going to live?
I was gonna go to the homeless center again, but I would like to go over to mental health over here across the street, kitty corner from the jail, and see if they can find me a three-quarter house living. I need to get back on my Social Security. I know that. Disability.
And I do know that incarceration does affect that.
Yeah. I'm mentally ill, ma'am. I've been mentally ill for years, and I have no help over it. I can't do nothing about it. I have to take medicine for it in order to function, ma'am. And mental health over here takes care of me, and they're going to find me a place to stay, they said.
Well, and Mr. Matucci, what I'm really glad I hear is that you recognize that you have a need for help and that you want to get that help. Because that's a lot of the battle that a lot of people don't understand, is that we all have needs for help in different ways. And that's okay to need help. And you're recognizing that you have mental health needs that you need help for. And getting that help is the most important thing you can do. And you can't get help if you don't recognize it. So I'm really proud of you for recognizing that.
And then they take me to and go get my meds and everything. They'll have a place, a roof over my head and everything if I could get out today, ma'am. I don't like to ask. I have no, that's not my only problem is money. And I used to have it. I used to be able to pay my bills. I used to be able to do my rent and get my food. I used to have no problems living as a functional person, taking my medicine and living in the community. It's just
Mr. Matucci, let me tell you this. I don't want to keep you in the jail, not on a property crime.
All right.
I also want you to be warm, and the temperatures are going to below freezing this weekend.
I know it. I know it.
My concern is to ensure to ensure you have somewhere to stay that is warm, and to ensure that you are going to back to court.
Yeah, I will, man. I will go back to court. You have my word on it. I'm not.
Now I have good news. I hope you find it to be good news. The good news is you're staying on my docket, so you're staying with me. So I just need you to come back to court with me.
Well, ma'am, I would like to go to the homeless center where it's nice and warm. I can at least smoke. I smoke. I'm a smoker. I like to smoke.
It's okay. You can smoke. If that's what you need to do, you can smoke. I'm going to give you a $5,000 personal bond. You will not post any money. We
didn't notice.
Will get released from the jail.
When will I come back to jail? When will I come back to court?
I'm going to tell you that next. No contact with Walmart. You cannot go to Walmart, okay?
I won't go.
Deal. Solid. You're going to come back to court with me on February 4th.
What's today's date?
January 22nd. So it's just under 2 weeks.
Okay.
I'm going to put that hearing on Zoom. So if you are in the shelter and you just want to call in or video in because you can't get transportation here, you can do that.
Okay.
But if it is easier for you or better for you to come here in person, you can do that too. I'm here. So you are welcome in the building.
Is this downtown Macomb County? I gotta go?
This is on Gratiot and Roseville.
No. Oh, okay.
Okay,
where do
so
I
you're
go?
welcome in the building. You are welcome to be here with us. But if it is easier for you to be on Zoom, I'm going to set it on Zoom so you can do that too. I just need you to be with me on the 4th. Is that a deal?
On the 4th? Yeah, I'll come back. Yes, I will come back, ma'am. If I come back, will you promise to help me with my Social Security? If I can't get it by
but I did appoint you a lawyer who you can talk to about that.
Okay, thank you. Okay. That'll work. I'll see you on the 4th.
I'll see you on the 4th.
Thank you, ma'am.
You're welcome.
All right, hopefully I have everyone. Thank you for joining us this afternoon. Please keep your microphones on mute as we start the proceedings. Good afternoon. This is Judge Todd Wong. I'm residing in Travis County Court at Law Number 1. I'm calling the docket this afternoon. Today's date is January 22nd, 2026. All right, thank y'all. Let me go to the next one, CV 25-6466, Texas Department of Criminal Justice versus Progressive County Mutual.
Hi, Your Honor. Vishal Iyer, counsel for Texas Department of Criminal Justice. We're ready to proceed.
Doyle Jackson for the plaintiff, Your Honor.
For the Progressive?
Yeah, I'm sorry, Your Honor. Yes, Progressive.
Thank you.
Wait, I don't think that's the lawyer is that the lawyer representing Progressive?
Mr. Jackson, are you here on behalf of Progressive?
Yes, Your Honor, I am.
Okay.
I'm appearance counsel. That may be what's confusing.
Okay. Thank you very much. All right.
Judge, can we figure out who Daniel Rosales is?
Mr. Rosales.
I apologize. Daniel Rosales is my legal assistant at the Office of the Attorney General.
Okay, thank you.
Okay. All right. Let's yank in 25-6466, Texas Department of Criminal Justice and Progressive County Mutual. All right. Let me see if I can get y'all's cheerful faces on here. There we go. Ms. Iyer, you're here. I don't have to see Mr. Rosales necessarily, or I think somebody else. Yeah, no, Addie was in the other one. All right, very good. And Mr. Jackson is here. All right, this is a motion for summary judgment, 25-6466. These aren't recorded. I mean, they're not. We don't have a transcription of these. So, Mr. Iyer, you have filed a motion for summary judgment. You filed also a reply to the response.
I just don't understand why Mr. Iyer is questioning Mr. Jackson and his appearance and whether or not he's legitimate counsel for Progressive. Looks like a fine, upstanding gentleman to me who didn't spell his name properly. Maybe I should move over to the side for this one.
I've read both. You can, even though y'all announced for an hour, I can assure you, and I know you don't want to be sitting on a Zoom call for an hour. So, Mr. Iyer, you may proceed first.
Sure. I appreciate the court's review of the record. Vishal Iyer, counsel for TDCJ. This is a motion for summary judgment in a case for bill of review. TDCJ is the bill of review plaintiff. Progressive County Mutual Insurance Company is the bill of review defendant. The motion is supported by the following evidence: the original petition in the prior suit, the attempts at service in the prior suit, and the default judgment in the prior suit. Those are exhibits A through C. TDCJ is a state government agency. Progressive is a domestic insurance carrier that has moved its principal office outside Texas. In the prior suit, what happened was on August 16th, 2023, Progressive filed its original petition against TDCJ as defendant in the prior suit. For the case in the prior suit regarded a car accident, and Progressive alleged that TDCJ's employee was negligent in the operation of a motor vehicle. On November 28th, 2023, a private process server personally served the Texas Secretary of State by personally delivering a copy of the petition and citation to an authorized person. This was the only attempt at service. Additionally, counsel for Progressive emailed a copy of the petition and citation, although this, I don't think even Progressive contends this is service, to an internal TDCJ email address on February 25th, 2024. On March 4th, 2024, this court entered a default judgment against TDCJ, even though it did not waive service or enter an appearance. This motion raises two issues. Was TDCJ properly served in the prior suit? And did TDCJ's own fault or negligence contribute to cause the lack of service? Because there is a little bit of dispute between the parties on the proper standard, I'll just go ahead and say it. A bill of review is an equitable proceeding brought by a party seeking to set aside a prior judgment that is no longer subject to challenge by a motion for new trial or direct appeal. Ordinarily, a plaintiff must plead and prove a meritorious defense to the underlying cause of action, which the plaintiff was prevented by making the fraud, accident, or wrongful act of the opposing party or official mistake unmixed with any fault or negligence on its own. But when a bill of review plaintiff claims a due process violation for no service of process or notice of a judgment, it is relieving of proving the first two elements and must only prove that its own fault or negligence did not contribute to cause the lack of service or notice. So the threshold issue is, was TDCJ properly served in the prior suit? And Progressive's only attempt was to serve the Secretary of State. Texas Government Code 492.010 paragraph D clearly states that TDCJ's executive director is the only person authorized to receive service on behalf of the department. This was a case against TDCJ. The only person who could have received service was the TDCJ director. The TDCJ executive director is not the same person as the Secretary of State. So as a threshold matter, service in the prior suit was not proper. And then regarding the element on whether TDCJ's own fault or negligence contribute to the cause of lack of service, there's not much case law on what this element requires. The closest I've found is the case of ICAR Houston LLC versus Broussard. And in that case, the 14th Court of Appeals held that a failure to update a registered address for a private company constitutes negligence in the service of process context. So you can't fail to tell the person where you need to be sued, and then ask for a bill of review once you get a default judgment. That is not at issue here. The legislature has made clear exactly how to serve TDCJ, just serve the executive director. So the manner of service was always clear, and so TDCJ's own fault or negligence not contribute to cause the lack of service. In its response, Progressive basically argues two things. They cite two generalized Texas rules of civil procedure and applicable statutory requirements and say service was proper. And then they say TDCJ is barred from a bill of review because it failed to appeal the denial of its motion to set aside the default judgment and for new trial. So again, I have not seen one citation on where they say serving the Secretary of State qualifies for serving TDCJ, and they don't address Section 492.010D altogether. So, while you may be able to serve a different state agency by serving the Secretary of State, I don't know. I don't represent the other state agencies for the most part. For TDCJ, there's only one way to do it, and that's through its executive director. So service as a threshold matter was defective in the prior suit. And then sort of
Counsel, is there a difference between the Texas Board of Criminal Justice and the Texas Department of Criminal Justice?
There is. So
why don't you tell me the difference? Because the statute you're looking at and the provision you're looking at talks about suits by the board or against the board. And that's really not what I'm looking at in this case, am I?
So let me see. So the title of Government Code 492.010 that says suits by the board, I mean, that is not actually the text of any statute. The text of the statute itself in subsection D, admittedly, is a little bit broader than the earlier parts, which sort of talk about how the board may sue. But Section D, which talks about how the board is sued and the department is sued, and any division of the department, such as CID or any other like jural entity. So, yeah, subsection D clearly does state that, and clearly does control. And it does apply here because it says the executive director is the only person authorized to receive service on behalf of the board, department, or any division of the department. There's 3 different entities that if you're going to sue, then you need to serve the executive director of TDCJ. And there are differences between TBCJ and TDCJ that are somewhat nuanced.
And in the default proceeding or thereafter, there was some time that was delayed by the AG's office. They eventually did try to file something, but it was too late, wasn't it?
Yeah, so what happened was the default judgment was entered. We were notified of the case after the default judgment was entered. My predecessor in this case, Mr. Sydow, then filed, so within the 30-day period after the default judgment, he filed a motion for new trial, essentially saying service was improper. And then it was set for a hearing, I understand, sometime after the plenary power had already expired. And then, so what Progressive is saying is no matter that service was improper at the outset, by not appealing the denial of the motion for new trial, we are then barred for a bill of review. And then they cite, so moving, if the court has any additional questions about 492.010D, I'm happy to address them. But Progressive's ultimate argument is that there's a trio of cases that then forecloses a bill of review. And those cases just aren't relevant here because again,
Well, I saw some smart alecky comments in your motions saying that the sophisticated insurance company and their sophisticated counsel are expected to know the law. That seemed to be a little bit unnecessary, don't you think? As far as language goes and presenting to the court.
I mean,
oh, you don't think that's smart alecky? I do. I think it is. I'm going to tell you right now, I don't think that's really appropriate. You don't try to nudge somebody on the opposing side saying, well, they're sophisticated and they're smart and they should know the law. I mean, come on. Let's grow up, shall we?
Sure.
All right, what else? What else do you have?
Well, I mean, this is an issue of sovereign immunity. So
And the irony of him talking about, they're sophisticated lawyers, and then this guy shows up.
Ultimately, all of these, you cannot, the background is presumption is that all the state of Texas and its agencies are entitled to sovereign immunity. The waiver of sovereign immunity that the legislature has made through 492.010D and the requirements for personal service all tie in together. So to waive sovereign immunity includes concerns about subject matter and personal jurisdiction. By failing to properly bring TDCJ into the suit in the outset because Progressive failed to consult 492.010D's very clear requirements, TDCJ was not properly before the court. So there's the personal jurisdiction sovereign immunity angle too. So yeah, so that's the ultimate argument. But the way Progressive styles its argument is they cite to 3 cases. They cite to French v. Brown, Rizek v. Mayad, and Hedefin v. Harker. None of these cases are apposite here. French was a contract action involving private parties where the case was about a lack of notice of the motion for summary judgment and its hearing. Rizek was a fiduciary action involving private parties, and it was about the lack of notice of the intent to dismiss or the actual dismissal. Again, not about lack of service. And Hedefin had nothing to do with a lack of service or notice, instead boiling down to a simple disagreement about attorney's fees after a bench trial. None of those 3 cases are relevant whatsoever. And secondly, TDCJ's limited post-judgment appearance in the prior case solely to vacate the default judgment and secure a new trial, unlike the expansive general appearances of the Bill of Review plaintiffs in French, Rizek, and Hedefin, did not waive its objections to personal jurisdiction through lack of service at the outset. And as I mentioned, personal jurisdiction is a component of sovereign immunity, and the waivers of sovereign immunity are strictly construed. So Because, and the plaintiff also had the burden to allege a waiver of sovereign immunity. And so here, the waiver of TDCJ's sovereign immunity depends on, among other things, progressive strict compliance with the legislature's crystal clear rule that you need to serve TDCJ's executive director. They failed to do this, and therefore TDCJ is entitled to sovereign immunity for both subject matter and personal jurisdiction because progressive service in the prior suit was defective.
All right, and just kind of tell me, so the motion to trial wasn't heard timely, so y'all kind of knew that. Judgment determination was made by the court, kind of alerting your predecessor, I presume, that there was no longer plenary power. Why did it take over a year to file this motion, this action? I mean, that was in 24, right?
Sure. I mean, so this action is still timely. So this action, it must be filed.
No, I'm not saying it's not. I'm just saying, why did it take over a year to go ahead and launch this?
So I only got this case substantially after everything concluded. I mean, yeah, I don't have a better answer than that.
That's all right.
Yeah.
I don't want to throw dirt on your predecessor, but I kind of am. But anyway, all right. Thank you, Mr. Jackson. You have drawn the fickle finger of fate to be appearance counsel in this. You have a response, sir?
I do, a very brief one. I'd like to focus on some of the facts. The plaintiff has not alleged that they didn't know about this suit. They didn't allege or provide any evidence that the Secretary of State didn't notify them. They concede that they got a notice of this suit. Excuse me.
Yeah, but does that matter? Does that really matter? Because if the service was never effectuated correctly, then it's been doomed from the start.
I think it is, Your Honor. I want to refer the court to Ward versus Nava, where the court said in a situation of this nature, the question of lack of service is purely a question of fact, which must be determined by the trier of facts and the testimony of the moving party alone, without corroborating facts or circumstances, is not sufficient to overcome the presumption that officers' return on the citation was correct. And I would also refer the court to Caldwell versus Barnes, where the court said bill of review plaintiffs alleging they were not served, however, must still prove the third and final element required in a bill of review proceeding, that the judgment was rendered unmixed with any fault or negligence of their own. I believe that they had notice of this suit, maybe not served properly, but they did have notice of this suit. And so they knew that it was possible a judgment could go against them. I think a reasonable, prudent party and a reasonable, prudent lawyer would file a motion to quash while the suit was still alive. And that's all I have in response, Your Honor.
Okay. All right. I'm curious, though, how, well, your appearance counsel, but how regular counsel would address the statutory issue with the government code, and the only process of service would be allowed through the actual executive director and not by any, serving a representative of the Secretary of State. I understand that Secretary of State can be the recipient of service for various entities unless the statute provides specifically. And in this case, under this particular government code, it does specify the director is the one who has to be officially notified and served with process.
Yes, Your Honor. I can reply to that. It is our position that statute applies to the board.
Right, but D talks about as far as not only the board but also the entity itself. So I only brought that up just because I'm curious as to where everybody lands on it. Okay. Anything else, Mr. Iyer?
I would just mention that it's clear that the return of service shows that the service was only on the Secretary of State, and all of the cases cited by opposing counsel regard private parties. This is a suit against the government. There's just different rules. Sovereign immunity is the backdrop. To waive sovereign immunity requires to strict compliance with the legislature's mandates. That's all.
And Mr. Iyer, what are you seeking in the summary judgment this afternoon?
So we're asking the court to vacate the default judgment in the earlier case, reopen the earlier case and grant a new trial after a hearing, and then subsequent to that, issue a hearing, render judgment that Progressive take nothing, assess costs against Progressive, and award us all other relief to which we're entitled. But
okay, all right. So, but mainly for this part, you're asking the court, based on the summary judgment, to vacate the prior order back in 24 and to give you all a new trial.
Exactly, Your Honor.
All right, and that's over $4,800 is what I'm looking at.
Yes, Your Honor.
I love you guys.
One of my favorite parts about this job.
I know. I'm sorry for both you and Mr. Jackson. Mr. Jackson's the only one who's maybe getting paid a nominal fee just to show up by Zoom, but I appreciate the argument. All right, let me. Did you send me a proposed order?
Yes, Your Honor.
Mr. Ryan? Okay, I'm going to take a look at it, and I'll take it under advisement. Mr. Jackson, thank you. I'm looking at it. Let me put it that way, and you can tell your other counsel that you put up a tremendously heated argument on behalf of Progressive. But in the event that y'all end up ever having to go to trial in this, I'm sure it won't be in front of a jury, and I'm sure neither one of you will still be alive when it happens. Well, yeah, Mr. Iron. Well, I probably won't be. You two got it. Anyway, I'm going to take it under advisement, but I've got the order, and I'll mull it over. I'm going to check with my staff attorney to make sure I haven't completely missed the boat here. But I appreciate it.
One additional thing, Your Honor.
Yes, sir.
I did include a proposed order at the end of the MSJ. It's right. It's actually not a numbered page, but it's
okay.
Right after page 8. I can also send it to the court, but I wanted to highlight that.
Okay. No, I think we're okay if I've got it in a form that I can work with. If I'm going to work on that one.
Okay.
We'll keep the suspense alive. So, all right. Thank you. Thank you all very much. Please be safe this next few days. I know it's going to be nasty.
Guys, yeah. Okay. I saw that one. He's going to try and argue that too. It says in there she gets to make it up.
Mr. Green, you're not on mute.
Oh, sorry. Thank you, Your Honor. I turned my camera off.
Yeah.
Turning your camera off doesn't stop them from hearing you, sir. Completely different sense.
Thank you for that.
Ready? Good afternoon. Matter on the court's docket is Watasik versus Watasik 41-2022 DM 14. In this case, well, first I'll note appearances. Attorney Jonathan Green is present on behalf of Katie Watasik. Ms. Watasik is present by reliable electronic means. Attorney Samuel Johnson appears on behalf of Andrew Watasik. Mr. Watasik appears by reliable electronic means. I am physically present in the Barnes County courtroom in the Barnes County Courthouse. The door is unlocked and open. This is a Sargent County matter. The Sargent County courtroom and courthouse are open to the public. We are live streaming today's event on the Southeast Judicial District's live stream YouTube channel. These are open and public proceedings. Procedurally, this is the status of the case. The parties entered a stipulated judgment back in 2022. There was findings of fact, conclusions of law, and order for stipulated judgment, record index 94. The judgment was record index 95. Thereafter, there were a number of proceedings that occurred in front of a different judge. Ultimately, the matter was closed. In 2025, the matter was reopened for mediation January 2, 2025. Nothing occurred other than a family mediation closing form was filed, record index 173, on March 13, 2025. On 12/11/2025, Mr. Wojtasek filed a number of documents, including a demand for change of judge against Judge Cruff. I was appointed thereafter. There was a motion to modify or amend the judgment. That was filed, record index 176. That motion was scheduled for hearing. Shortly thereafter, there was a motion for a continuance filed by Attorney Green, record 186. The court granted the motion to continue the hearing over the objection of Attorney Johnson. The court entered an order granting the motion to continue, record index 206. So the motion to amend the judgment remains in play and has not been ruled on. The court has attempted to reschedule that hearing and is still waiting for responses from one or both of the attorneys as to scheduling that hearing. But the gist of the resistance to the continuance was that Mr. Wojtasek had plans to take the party's children to Hawaii on January 15, 2026 through February 1, 2026, an issue that Ms. Wojtasek objects to. The court, again, has not ruled on the motion to amend or clarify the judgment. There's some dispute as to whether or not it's a motion to amend or a motion to clarify. The court, in its order, granted the motion to continue, and again, has tried to reschedule that hearing and has not been successful in doing so yet because the court is waiting on responses from some of the parties. Yesterday, on 1/21/2026, Ms. Wojtasek filed a motion for ex parte emergency interim relief, record index 210, and a brief in support, together with a motion for contempt, a notice of motion for contempt, a brief in support, a declaration, a number of exhibits, a financial statement, and a proposed order for ex parte interim relief. That matter was detailed to the court today for its consideration. So the first I knew of the ex parte motion was this morning. The court, pursuant to Rule 8.2 of the Rules of Court, scheduled this afternoon's hearing on an emergency basis, which it is required to do when it knows that parties are represented, before considering an ex parte motion for interim relief. The gist of the motion for contempt, which is not ripe for the court's consideration, and the gist of the motion for the ex parte motion for interim relief is, despite the fact that Mr. Wojtasek knew that Ms. Wojtasek objected to him taking the children to Hawaii, which was the basis for his motion to amend the judgment, and the reason he asked the court not to grant the continuance, which the court granted, was that he had plans to take the children to Hawaii. He knew that Ms. Wojtasek objected to that plan for various reasons. The court denied the request to hold the hearing on basically an emergency basis. It wasn't presented as an emergency motion, but the court granted a continuance over objection. So unquestionably, Mr. Wojtasek knew that the court did not give him authority or permission to do so. Now the court has received information, and the gist of the motion is that he took the children anyway, that he pulled the children out of school on the 14th of January, drove the children out of state to Minneapolis, and then hopped on a plane with the children to Hawaii, and that the children are now in Hawaii for an extended period of time. Ms. Wojtasek in her motion argues that doing so has injured the children on an immediate basis because the children are now pulled out of school for 12 school days, that they are missing other events, including confirmation, religious classes, dance, and another sport, and that her parenting time is being interfered with in contravention to the stipulated judgment. Mr. Green, did I accurately summarize your motion?
Yes, Your Honor.
All right. So it's your motion. I'm going to give you an opportunity to be heard on it, and then I'll give Mr. Johnson an opportunity to be heard on it. Then I'll issue my ruling on the motion for interim relief. I am not going to address the issue of contempt because I don't believe that's ripe and properly before me. And we will potentially be scheduling all of the hearings depending on the court's ruling. And while I have the parties connected, we're going to take up the scheduling of Mr. Johnson's motion to amend the judgment together with any scheduling issues we need to address with the other two pending motions. Go ahead, Mr. Green.
Thank you, Your Honor. I think I've laid out the facts. Well, the court just laid them out. So I think based upon the court's assessment of what I've drafted and submitted to the court, I've done a fair job of conveying what Ms. Wojtasek has wanted me to convey. But yes, we do believe that there is an injury to the parties here, and that both the girls, the children of the parties, and Ms. Wojtasek are in need of protection. As I noted, Mr. Wojtasek unilaterally decided that he was going to take these children on a vacation. I believe that Mr. Wojtasek is going to argue that he's entitled to take the children on a vacation. As paragraph F reads, that extended family relationships are an important part of the children's lives, and as such, each of the parties shall be entitled to time with the children for special family occasions, such weddings, reunions, vacations, graduations, and such for reasonable periods upon reasonable advance notice.
The kids are in Hawaii right now. The only thing that they are in harm of is sunburn. Personally, I feel the mom is making much ado about nothing.
All right, I want to address that primarily because I think the rest of my brief speaks for itself, but I want to be clear. First of all, Mr. Wojtasek is not on a vacation with extended family. He's on a vacation with his girlfriend and his girlfriend's kids. Now, this court has read an order in this case where Ms. Wojtasek allowed her children to go to her parents. Now, her parents are extended family, and yet the court in that instance still said, well, too bad, so sad, you violated the order, you are in contempt. So if we're going to read these judgments as literally as that the court did, and it wasn't you, Judge Thornton, that issued that decision, but if Mr. Wojtasek was going to be that nitpicky about whether or not the kids should be with him or with her family, then I think the court needs to also look at this particular paragraph and say, yeah, he's not over there with extended family. He's over there with his children, his girlfriend, and her kids, and her family, who knows what. But even if we could get past that, Your Honor, it says for reasonable periods upon reasonable advance notice. This isn't a reasonable period to take your children out of school for 2 to 3 weeks every single year. That's not a reasonable period. Most schools have a policy that if you miss 10 days, and this court received as evidence, part of that, you miss 10 days, you're going to get a nastygram in the mail. And despite Andrew's assertion in his previous email that he had taken care of things, they still received a letter from the school saying that they've missed too many days. And And to miss 10 to 12 days of school every year is completely unacceptable. It's not reasonable. So paragraph F doesn't apply in this instance because it's not extended family and it's not a reasonable period. Or I'm sorry, it's not. So it's not a reasonable period to be missing school. In particular, when the other parent doesn't consent to it. And I didn't draw the court's attention to it, but I know there are statutes about school attendance, North Dakota Century Code Chapter 15.1-20. I was trying to get this thing filed because I knew Andrew wasn't bringing those children back this Sunday. And it's time for the kids to get back to school this next week. So I also didn't file the attendance policy at Hankinson. But I will be bringing that up at a later point in time if this motion is granted. Today, the crux of the case is: do the children need protection? Does Katie need protection? Do both groups, do both Katie and the children need protection? If this court finds that the children need protection, that Katie needs protection, or both, then it needs to issue an ex parte order and require Andrew to return home. We're requesting by this Sunday so the kids don't miss any more school. Thank you.
Yeah, they need like SPF 90. Oh my goodness. I get it. I get it. He did it outside of the court order. But can you imagine if for the rest of his life he had that over his head where she's like, yeah, remember the last time you didn't listen to me and you had to bring the kids back from Hawaii? Oh, I could just.
Thank you, Your Honor.
Mr. Johnson, do you have any response?
I do, Your Honor. Your Honor, the first thing I want to clear up with the court is how this has been completely taken out of context from the very beginning. That my motion, where I asked for a clarification of the additional parenting time that he was so granted in the judgment.
So,
And
Mr.
also,
Johnson, I'm going to stop you right there. Where in your motion does it use the word clarification?
here's the thing, Judge. Initially, I probably used amend. We're beyond that, but here's my problem. The court seems to have this supposition that because it denied or granted the continuance, that somehow that uniformly denied him the right to take this vacation. And I need to clear that up. And I need an opportunity without interruption to clear that up.
So I'm going to give you an opportunity, Mr. Johnson, but there's a couple issues that I need to clear up before we move forward. A, your client received my order granting the motion to continue where I made it clear that I was not going to take up your motion to amend or clarify until we had a hearing on the matter, which would be scheduled in the future, correct?
That's absolutely correct, Judge.
All right. So we're still operating under the December 2022 stipulated judgment. That's the operative language setting forth the parties' rights and responsibilities, correct?
Absolutely.
Okay. And so that's the operative document. Nothing has changed since then, right?
That is correct.
Okay. So going from there, is it also true that after receiving my order, your client removed the children from school and took them to Hawaii over Miss Wojtasik's objection?
Yes, he has the children. He's taken the children to Hawaii, but he is
all right. So
authorized to do so.
Stop. Where in the December 2022 judgment does it say I'm cool to take the kids out of school for 2 weeks.
Okay.
Take
Can
them.
can I present my argument now?
You can answer my question first, Mr.
That's my argument,
You're
Judge.
interrupting me, Mr. Johnson. Where in the judgment, I want a specific paragraph, page number, and subpart.
All right.
Where in the judgment does it say that that's okay?
In paragraph 10, in paragraph 10, F, G, and H, Your Honor. In paragraph 10, F, the paragraph specifically provides the parties understand that extended family relationships are an important part of the children's lives. As such, each of the parties shall, doesn't say maybe, doesn't say get permission, it says shall, be entitled to time with the children for special family occasions such as weddings, reunions, vacations, graduations, and such for reasonable periods upon reasonable advance notice. The very next paragraph states, when possible, the party requesting time with the children for such events shall provide notice to the other no later than 15 days prior to the occasion. In this case, Your Honor, we mediated this matter. Notice was given to them on March 13th, 2025. She admits in her declaration that she was also given notice at the parent-teachers conferences, which was in the second week of November, 2025. Her declaration also memorializes that she admits she got a notice on December 15th. Mr. Green and I have had many emails back and forth with regard to this issue because it was part of the mediation which they literally showed up to and walked out on March 13th, 2025.
I don't want to hear about mediation. There's a mediation agreement that says that there was a partial agreement made, but I've never seen a stipulation. Nothing was filed thereafter. So I don't know what happened there. And mediation is settlement communications for which this court is not a party. So,
well, the one thing you have to be aware of, Judge, is that Mr. Green has put in his documentation that according to paragraph 12E, that in the event the parties have a major decision, the party shall work through a qualified third party appropriate. And he's saying that we can't do this because we haven't mediated it yet. We did mediate it. In fact, not only was that not submitted to the court, Your Honor, but if you take a look at her declaration, in her very declaration, if you look, I believe it's exhibit 2 or 3, the same evidences, exhibit 3, the same evidences where Andrew says to her, actually, you walked out of mediation and refused to discuss it in relation to your move. And so not only did she have notice of this issue on March 13th, 2025, she had notice of it in November of 2025. She had notice again in December of 2025.
Nothing was agreed upon.
so stop.
And so according to F, the parties shall be entitled to time with the children. Now, it also says in G, the party receiving notice shall respond to the proper request in a timely manner. Permission for the special question will be deemed granted, and the children shall be made available for the occasion. So regardless of whatever she said, it's granted, okay? But then there's compensatory parenting time, which is also addressed in the very next paragraph. So this, by operation of law, Judge, number one, he requests it. He gives her notice of it. It's granted automatically. 15 days has to be provided, which it was, probably 6 months was provided or more, multiple times. It's deemed granted. And then here's the thing. If you look at H, in the event that special family occasion parenting time interrupts with normal parenting time schedule, such that either party's regular time is missed, that party shall be entitled to compensatory parenting time of the same duration to be mutually agreed upon by the parties. Clearly, we're going to give her compensatory parenting time. There's no question about it. The minute she gets back, they'll negotiate it. She'll get that time. If you notice, it says the same amount of time in this judgment, and Mr. Green has asked for double time. In fact, not only has he asked for that, Judge, but he's asked to suspend my client's parenting time. And that takes a whole different animal to be able to have this court order that. But the fact of the matter is, Judge, no matter what, if we had that hearing on January 8th or not, he was going to Hawaii. That had nothing to do. I wanted to have the hearing, so perhaps the judge could make a decision on that. But that, if you would have said no on January 8th, we don't go. We don't go on January 8th if you make that decision, because you're saying no. Okay, but we're going to bring all of this up at the January 8th hearing, all of it. And because we didn't have the hearing, had nothing to do with the fact that he was denied this right to go to Hawaii. In addition to that, Judge, here's the thing. All of the teachers have been notified. The principal's been notified. We have got everything. They're doing the homework in Hawaii. Everything has been arranged. I am looking at a letter which they didn't get to the court, and I didn't have time because it just got this morning, where the principal is saying, have a nice trip, everything's taken care of, all is good. All the teachers have confirmed this. There's been numerous amounts of communication between Andrew and these teachers and the principal. All of this is taken care of. And if you noticed in my previous motion, Judge, when she, this is an annual trip, they take this every year. When he did this last year, she, of course, opposed it and claimed, oh, they didn't get their homework done and all of this and that. But in my motion, you'll notice I had the foreman school submitted documentation saying, no, everything was fine. Everything's good. She loves to pound.
So, Mr. Johnson, I haven't reviewed all of that evidence because that motion isn't before me right now. So you're referring to evidence that I haven't received.
I don't. However,
and I need you to answer this question. So you cite 10 F, G, and H, right?
Correct.
And all of them refer to extended family relationships. That's the primary purpose, right?
Correct. And I'll explain that.
Okay. Well, you haven't yet. So Mr. Green argues that this isn't an extended family relationship. This is a blended family relationship.
Okay.
That's how I'm going to describe it.
Okay.
Right? That's how I think Mr. Green is characterizing it. So tell me how it falls within F. If F and G and H refer to extended family relationships, and Mr. Green is arguing this isn't an extended family relationship. This is Mr. Wojtasek going with a girlfriend and girlfriend's kids to Hawaii. So I'll answer that question.
Okay. So, Your Honor, they've been taking, so let's back this up. Mr. Wojtasek and Ms. Chisholm have been dating for years. Okay. They've been together for years. All right. He has 3 children. She has 2 children. They're together all the time. Okay. In addition to that, Your Honor, Andrew and Katie's children have met Erica's extended family, her sisters, her brothers, her father, her mother. They have spent extended amount of time with each other. They have taken multiple trips together. These kids have been so many states and so many places together. This is something that just didn't happen yesterday. Mr. Green knows this, right? Now, let me give you the facts of this, Judge. Erica Chisholm's father recently passed away. Erica Chisholm's father was and had a significant relationship with these children, all 5 of these children. He passed away. There is a celebration of life scheduled for him in Hawaii to scatter his ashes at the place that he has enjoyed every year, that he and his family have gone to for years and years and years. That's part of this celebration that the kids And her entire family is there. Andrew and his family is there, his 3 kids. And that is part and parcel of what is going on in this 2-week, time frame that they're out there. And so this isn't just a willy-nilly, we're just taking a trip, we're headed to wherever. The Chisholm family has gone out there every single year for years and years and years. Andrew has gone out there for years with Erica. The children have gone out there, went last year, now this year. They went out there this year for the celebration of life for her father, to spread his ashes. I'm assuming in the water of the place where he's gone to for years and years and years. So this isn't just, oh, we're just taking the kids and running somewhere. This is where they have been vacationing for years. And so that's the story, Judge. Now, if she wanted to deny those children the right to celebrate their, essentially their step-grandfather who passed away recently, and very recently, Judge, the ability to celebrate that with the entire family. And remember, this is a family that gets together all the time. This isn't like my brother who lives in Florida, I see once every 4 years. These guys are all together all the time. They're vacationing together all the time. It's just a different familial network. And Andrew and his children are included in all of that. And so that's what I mean by this, Judge. This trip was going to happen. I made the motion in the hopes that I would be able to get into court prior. Did I delay? Should I have done it earlier? Yeah, absolutely. But, I had the date set up, had no idea Mr. Green was going to have a conflict. But regardless, he was taking the trip. So the fact remains is, what's the injury here? You have to look at 8.2. And 8.2 requires exceptional circumstances, meaning imminent danger or circumstances necessary to protect the children. Now, if you take a look at that, Judge, and I have pulled a few cases on that, this involves cases where we have sexually molesting somebody and taking photographs of child's private parts, like in Jensen versus Deaver, or where a father masturbated in presence of his teenage daughter on multiple occasions, like in Lidoff versus Pinter. But here's a case right on point, Hendrickson versus Henderson, which says suspended parenting time was not proper when the mother repeatedly frustrated visitation orders and attempted to alienate the children from their father, remove the children from the home at the father's scheduled visitation times, and refused to allow the father to take the children for visitation. And so what you're looking at here in that particular case, their allegation is, well, he's taken away her parenting time.
Well, in those particular cases, I can understand parenting time being taken away. But this, he took the kids on a planned trip to Hawaii. It's a little different.
Even though he's authorized to do it, she gets compensatory parenting time. In that case, that's what that person was doing, and the Supreme Court said that doesn't fit within 8.2 at all. And so you have to look at these definitions of what is imminent danger and circumstances necessary to protect the children. What, in fact, are they doing? What is Andrew doing? Oh, they're not going to a few classes. They got that all taken care of. They're doing classes in Hawaii. Oh, she's not going to a dance class? Well, if you also take a look at their own declaration, if you look, Judge, at page 2 of exhibit 3 of her own declaration, Andrew informs her, also, you're aware that dance instructors of current condition and all of the performances are canceled. So there is no dance at all. They put that in there, but they didn't inform the court that this dance instructor has some serious medical or something conditions, and they're all canceled. So that doesn't have anything to do with anything. And so, If you look at the definition of extended family, a family that extends beyond the nuclear family, including grandparents, aunts, uncles, and other relatives who all live nearby or in one household. I mean, this is family, Judge. This is family. This is family that is together virtually every day that the kids are with Andrew. They stay overnight there all the time. I mean, this is, they go to horseback lessons here, they go to dance here in Wapaton. I mean, and they're doing it with Erica's 2 children. And so this isn't just a willy-nilly, let's just run off the whole Hawaii thing. Mr. Green talked about, they're missing too much school. Your Honor, this has all been approved, and the letters that he submitted are automatically boilerplate letters that the school has to provide if your kids miss more than 10 days. It's boilerplate. And so if you look, every one of them are the same. Everything has been approved. I got the principal's approval. We got the teacher's approval. I got letters to that effect. And of course they're going to get a letter. They're going to get a boilerplate letter. But that doesn't mean they have missed anything. They haven't missed anything in regard to their schooling. Everything is up to date. They're doing their homework every day. And in fact, there's communication with mom. They encourage the kids, hey, call your mom when she calls, FaceTime, whatever, telephone. So there's nothing being missed here in that regard.
Someone mentioned earlier that she looked like a teacher. And the more that I look at the room that she's in, it does actually look like a like the teacher's room, the employee break room for teachers. They've got the guillotine on the counter, and she's got the pile of papers there. Like, it really does legit look like a teacher's lounge. Maybe that's why the position of schooling is so important to her.
And she is going to get her compensatory parenting time. But I find it interesting how Mr. Green puts in his motion that, well, we got to go through this third-party qualified neutral. We did that. And it's evidenced by their own documentation. There's text messages that we have to her on July 22nd, where she's familiar with it, then the December. So she's had all the notice, Judge. There's nothing to qualify this as imminent danger, Judge. This, if you look at North Dakota Century Code 140522B, you can't restrict his parenting time, and they are asking, by the way, for a suspension of his parenting time, a complete suspension. They asked for the supervised in their motion, but in their order, they put suspension. You have to prove endangerment to the child's physical or emotional health. There's none of that. Judge, I got 50 pictures of these kids on the beach that I can't submit because the hearing was so fast. They're swimming and, they're on the beach, they're dancing with people there. I mean, they're having a good time. This just isn't what they're making it out to be. It's a simple vacation. And if she wanted to take a vacation in a couple of months or whatever, he has no problem with that, because she is going to get.
One of the things that I think Mr. Green is arguing is that it's 2 weeks of school. So if it was a shorter vacation, I think the argument would be quite a bit different if it was, we're going to fly out to Hawaii on a Thursday and we're going to be back on a Monday.
Mm-hmm.
They're going to miss a day and a half of school. That might be a lot different than if we're talking about 12 days of school. The boilerplate letter that you say is just boilerplate, that comes from a statute, and there's real harm. The reason that exists is that children away from the educational environment harms them. There's compulsory education requirements in the state of North Dakota until the child reaches the age of 16. That's, I think, the gist, or at least part of the argument. Now, it's hard, and I agree with you. It's hard to say the kids in Hawaii having a great time is the same as the kids being sexually molested or abused. But I think those are two very different things. But part of the argument about harm, if you read A1A, that's the threat of imminent danger. So I find that things like sexual assault of the children, that falls under 1A. And that's not what's being alleged here. 1AB is what I view Mr. Green's motion to be, which is circumstances indicating that the order is necessary to protect the parties, any minor children of the parties, or the marital estate. How is that a reasonable period? And when we talk about compensatory time, if the children are afforded 10 days during a semester and your client uses 12 of them, and then the remedy is give Miss Wojtasek an equivalent period, doesn't that just mean that the kids miss 22 days of school? How is that protecting their welfare?
Well, here's the thing, Judge. Okay. What John Green uses in his documents is the children are injured. There's absolutely no proof to this court that by missing 12 days of school has any negative effect on these kids whatsoever. None. There is none.
The court can't infer that missing 12 days of school results in harm when the statute says 10?
No, Judge, you're misleading that. If you look
I'm not misleading anything, Mr. Green or Mr. Johnson. Like,
they're required to send out a notice. That doesn't mean that there's danger to the children or circumstances are necessary to protect the children. It's a notice requirement by statute saying, hey, by the way, your kid's been out for 10 days. Okay. It doesn't automatically imply, oh, we've got a problem here. We've got circumstances that are necessary to protect these kids. We must have to get a motion involved or social services involved or anything to the like. All it says is, by the way, your child has accumulated at least 10 absences during this semester. We look forward to improving your child's attendance. Please contact us. It doesn't say anything that would even completely and remotely satisfy 8.2b, Judge. Nothing. And what's interesting here, Judge, is, I mean, there's nothing submitted to the court from the teacher saying, oh, this is going to be harmful. In fact, everything is going to be the opposite, Judge. There's nothing that she didn't go to the teachers. You know why she didn't go to the teachers? Because they all know and they all approved it. They all approved it. And so, I mean, even the principal knew about it, sent out an email. She's fully aware on January 2nd. Thank you for reaching out in advance to request the girls' schoolwork and for staying in communication with their teachers regarding any updates. The teachers will provide the work they are able to send ahead of time. Please note, however, that if snow days or other unforeseen events occur, there may be additional assignments that will need to be completed upon the return. Again, my apologies for not watching the email address closer. Have a great trip. This is the principal, Judge. They're encouraging this. Mr. Green assumes you missed 12 days, something's got to be wrong. No, it doesn't. It doesn't. Mr. Green used to take a trip to the Philippines for a month. Doesn't mean he wasn't something negative effect happened to him because he was gone from his work for a month. They're doing their homework.
That's a pretty bad argument. He's an adult. He misses a month of work. That's different than kids missing 2 weeks of school. I personally, I feel that, you know, as long as the grades are kept up and as long as the kids are still getting their education and everything, I'm kind of with the dad on this one, but I do get the argument. It would all depend. It's a case by case scenario. If they're good kids and good grades and everything like that, okay. If the parents are very involved in their education, great. Clearly, clearly, the mom did not approve of this. But I think that she's being a little bit bitter and short-sighted in doing so. Again, just my opinion.
And in the world of social or electronic communication, they can get all of that done. And I mean, kids didn't go to school for a year. They were on electronic communication. This is 12 days. I mean, there's nothing presented to the court which would indicate that circumstances are necessary to protect these kids. They're well taken care of. Their education is completely committed. The dance classes are all close. And how does, going to dance, whether or not you go to dance or not? I mean, when you look at the cases, Judge, we're looking at sexual molestation, father masturbation, physical abuse, psychological endangerment. That's what we're talking about here. In fact, in the Sims case, it says supervised parenting time restriction was not appropriate, even though the children's therapist testified that the father should have no parenting time based on what they've learned from the children. Even in the Sims v. Sims case, the therapist said dad should have no parenting time. Supreme Court overruled it. Those are the types of levels of endangerment or circumstances that you need to enter an ex parte order. I mean, Judge, I've literally had an adverse client driving intoxicated with kids in the car, and ex partes were denied. This doesn't even come close to that, and that was denied. And so what we're looking at is, it's 12 days, they get back, and she gets her compensatory time, whatever she missed. And remember, Judge, the 12 days of school, out of that 12 days, I'm not sure exactly how many days she's missing, but I think it was 5. I think she put in her declaration it's 5. And so Andrew has always been cooperative with her if she needed this or that or a day here and there or whatever. Clearly, we're going to give her these additional days as compensatory, which the parties contemplated, and this court ordered in paragraph 10H of their stipulated judgment dated December 28th, 2022. And so,
Mr. Johnson, isn't that the same paragraph you're saying is unenforceable?
What?
Isn't that the same paragraph you're alleging in your motion is unenforceable and overly vague, and therefore it's not in effect? Wasn't that part of the contempt finding from Judge Cruff?
No, Judge, that's J. If you look at J, the last sentence in J, it says Andrew should be entitled to additional parenting time during winter months as Katie's schedule allows. No, I
just wanted to double check. I'm trying to page between this and remember.
Yeah.
I'm the second judge on this, so there were a lot of proceedings that happened before. I want to make sure that you're not on one hand arguing this is enforceable and on the other hand arguing this is unenforceable.
Right. And what Judge Cruff did there was said, well, it's too vague. I can't find her in contempt, even though, by the way, we have repeatedly requested additional parenting time and she has repeatedly denied. But that's for a different thing. Now, the other thing I know that Mr. Green brought up a period of time where he indicated that Andrew denied Katie the right to have her kids over at her mother's or whatever. That was a whole different arena, Judge. That was a first right of refusal when she was going to a concert somewhere and not going to be with the kids, and she never gave him notice, and Judge Cruff found her in contempt of that. And so that had nothing to do with this situation that Mr. Green brings up. Completely different scenario. If Andrew, of course, wasn't you know, if the scenario was different, but that's completely different than this scenario. And so, Judge, I mean, clearly this just does not rise. It just does not rise. We have kids being, you know, and this is an annual trip. They go every year. And last year we went because she was found in contempt. We didn't have to make the motion. He was given 10 days of compensatory. So we just took it over that period of time. And
so, Mr. Johnson, I want to make sure I understand factually.
yeah.
So this divorce happened at the end of 2022, and you
Right.
said Ms. Chisholm and Mr. Wojtasek have been in a relationship for years and years and years. The way I look at it, we'd be talking about 2022 through present.
Yeah, it was after the divorce, of course, from between Andrews. So I mean, you know, it's probably sometime in 23, 24, 25, you know, we're looking at, and then now into 26. So I mean,
so this is the third time, right? And
I think it's actually going to be I think this is the second time, Judge.
Okay, so I want to make sure I understand. So there was an attempt in 2024.
No, I don't think so. I think they went in wait, let me hang on here. I'm in the wrong year here. Yeah, no, 25. They went in 25.
Well, they went in 25. They went in 25 because there was the contempt order, and I understand that.
Yeah,
that
in 26.
Judge Croft granted 10 days of compensatory parenting time in 2025.
Yeah.
And he did that in 2024.
No, I don't think so.
So his order was in 2024, and it said use it by June 2025, and they went in January of 2025. And so now we're in January 2026. And then there was an issue. Was there one before in 2020 or
no.
January 2024?
No, I don't think so, Judge. I don't think they went that year. I mean, let me put it to you this way. I believe Erica and her family has gone every single year, but I don't think that they were, you know, and again, I have to get this information from Andrea as far as their relationship, but I don't think that they went in 2024. You know, I don't know how long their relationship was at that point or whatever, but
okay, so just factually, I'm trying to make sure I have this straight. So in 2024, at some point, because there was a motion to hold her in contempt,
right,
there was a request to go either in 2024 or 2025. One of those 2 years, there was a request to go that was denied from Ms. Wojtasek. And then there was a motion to amend that was ultimately denied by Judge Cruff. There was a motion for contempt, and that motion was granted in, I believe, December of 2024. And then your client received compensatory time and went in 2025.
Yeah. I don't know about what you're talking about prior to this contempt motion. You said I made a motion to amend the judgment.
No, Mr. Green made a motion to amend, it's denied, at the same time that you made a motion to hold her in contempt. At least that's how I understood it, and maybe I'm misreading, and that's why I want to make sure I got my facts straight. So your client tried to go sometime in 2024, and that was denied. And then there was a motion to hold Ms. Wojtasek in contempt. That was granted. Your client exercised the right in 2025 in January to go pursuant to that compensatory time.
I don't think so, Judge.
Well, yes, your client went when they had compensatory time. So I'm assuming that was in January of 2025.
100%. But what you said before that was there was some kind of they tried to go in 24 and there was a motion and it denied it. I don't know about
what I'm saying is to hold her in contempt for not allowing your client to go, there would have had to have been a request in 2024 that resulted.
No, I don't think that. I don't think I requested it in that motion. I'd have to take a look, but I think the motion dealt with other things. I don't think and again, I have to look, but I don't think when I made that motion in 24 that I made a motion that he be allowed to go on that vacation. I made the motion for contempt because the paragraph said he gets additional parenting time, and I was hoping that at that point that perhaps the judge would define that. Instead of a motion for contempt, I should have made a motion to clarify this additional parenting time, which I did not. So I made a motion to fine her in contempt for not allowing the additional parenting time. The judge didn't fine her in contempt for that, but did fine her in contempt for failure to abide by the first right of refusal when she denied him parenting time on one occasion. So yeah, I never did. I don't think there's a motion before the court, me asking, other than this last one, for me to grant them the right to go, on this trip. I don't
Okay.
think
Well,
so.
and where I'm getting that from is paragraph 7, page 2 of Cruft's order
Okay.
concerning additional parenting time in winter. And I assumed that that meant for the purposes of taking the kids to Hawaii.
No, that was to find her in contempt of court for not allowing him. Remember, he's a farmer, so he gets like 5 months off. So he would like some additional parenting time during the winter. Well, she just continues to deny it. And Cruft said, no, I'm not going to fine her in contempt because it's too vague.
That is the one little detail that I've been waiting on. That actually, that's kind of my tipping point with the father. So yeah, I knew that, before you guys did. He's a farmer. So during the summer, that's his busy season. He can't take off during that time period. 2 weeks away from a farm, that's not going to happen in the summertime. So the only time that they can do this trip is during the winter. Does that make it right? No. They're, it still makes it so that they're missing school. It's not a justifiable argument other than it really can't happen any other time of year. So if it happens at all, it's going to be in the wintertime during school.
Because she's got the right if her schedule doesn't allow, and we don't know what that is. So that's why I made this motion to clarify. And I know it says amend, but I wanted to clarify that. But I understand the argument about the amend, and I probably should have used clarify. But so that was my fault there. But
And just to be clear, you're reading paragraph 10F, G and H to say that he has the absolute right over objection to take the children to Hawaii for 2 weeks.
yeah, Judge, and not only that, because H gives her the compensatory, so the penalty essentially, is well, okay, if you're going to do that, you're going to have to give her compensatory parenting time, or vice versa, whether she wanted to do it or not. So not only is the plan there, but the solution for it is there, And then when I looked at the judgment, it does have that qualified third-party neutral dispute resolution language in it. And I thought, well, I don't really need it because this resolves itself, but we did it anyway. And so I set up the mediation, and we did it in March, just so Mr. Green didn't have that argument. And so that has already been complied with. And so, but that had nothing to do with the fact that when I made that motion, he was going to go to Hawaii because all this was approved consistent with the terms and conditions of this judgment, F, G, and H.
All right. Thank you. Mr. Green, any response?
Yes, Your Honor. I couldn't help but notice that when Attorney Johnson wrote or read paragraph G to the court, that he stopped one sentence short of finishing it. Let me read it to you. I'll read the whole thing. When possible, the party requesting time with the children for such events shall provide notice to the other no later than 15 days prior to the occasion. The party receiving notice shall respond to proper request in a timely manner. Permission for the special occasion will be deemed granted, and the children shall be made available for the occasion. Here's the party skipped. Neither party shall unreasonably withhold consent of such event. Paragraphs F, G, and H contemplate consent by the other parent. This doesn't give the whole argument that it gives the person an absolute right to just walk off with the kids is hogwash. That's not true. It contemplates consent. He didn't have consent. He's never had consent. And if what Attorney Johnson is saying, they negotiated this or attempt to mediate this back in March, then Andrew's known since March that he didn't have consent, and he still did it. So F, G, and H don't apply for two reasons in this case. It's not extended family, and he did not have my client's consent. Now, there's been a lot of discussion about the children. I think the statutes are very clear. Legislatures do not put laws into place that are not meant to protect folks. They have the language in there for a reason. These kids are going to be gone more than 10 days. It's going to trigger that letter. But we're also looking past the harm that's coming to Katie. Andrew went to, Mr. Johnson just notified the court that Andrew went to the school, requested to get those kids taken from school, and did not include my client in that decision-making process. That's a violation of my client's right to participate in these children's education. When is it going to stop? Are we just going to let Andrew do whatever he wants, and then we'll just come to court and say, well, he'll pay, he's going to have to, well, she's going to get makeup time, so don't worry about it, because we're going to give him makeup time. And I'm sorry, Judge, but Mr. Johnson's characterization of the way Andrew treats Miss Wojtasik is absolutely, undeniably wrong. We're going to be submitting thousands of pages of text to you, and we'll show you how Mr. Wojtasik treats Ms. Wojtasik, not the way Mr. Johnson portrayed it at all. So he's a bully. Mr. Johnson likes to try and push it, like, just go, we'll deal with it later. Well, no, Judge, these kids need to come back. My client's rights as a parent need to be protected. These kids need to be protected. Thank you. And oh, and by the way, Judge, this mention of spreading the ashes was not in Mr. Wojtasik's declaration. If it meant that much to him, why wasn't it in there? And these kids have gone to Hawaii last year. This is their second year out there. That's it. This is not year after year after year they go. No. This is their second year. Katie didn't want him to go last year, but she was found in contempt, and she didn't feel like it was worth the fight. If he had 10 days makeup, she let it happen. She doesn't want this to happen every year, Judge. These kids are in sport. It's the critical time for these kids to develop their basketball skills, their dance skills, those types of things. They get taken away from that for a period of almost 3 weeks, 17 days. They're missing 12 days of school, confirmation, might not even graduate this year if she doesn't get back in time. And then here's the Judge, the shady part about all of this. Andrew's trip is for Thursday. Up until recently, he'd been taking the kids on Thursdays because he doesn't want to miss out on his parenting time because they have confirmation on Wednesdays. So what's he do now? He says, oh, I want my Wednesday back so I can skip town with the kids. That's what we're dealing with. These kids need protection. Katie needs protection. The kids need to be brought back to school. I'd like to see the kids return by Sunday. And Judge, if that's all you do on this, that's all Katie's asking for. Thank you.
Your Honor, may I?
No, we're going to address the other issues in the contempt motion.
So
before I issue my ruling, I want the parties' input on dates. Regardless of what I do on the ex parte emergency relief petition, ultimately I'm going to hold a hearing under 8.2 on the entirety of the matter, where I can receive evidence, and the appropriate mechanism for receiving evidence is declarations. The parties are going to strictly comply with Rule 8.2. There's not going to be supplemental declarations filed left and right. You're going to bring your big guns and file your motion and bring all of what you need to file at the right time, and it's going to be done once as allowed by the rules. We're also going to take up the motion for contempt. I'm going to hold a hearing on the motion for contempt. And we need to reschedule the motion to amend / clarify the judgment. All of those issues are going to be heard at the same time. All of those issues are going to be heard in the next 30 days. So the dates that I have available, Ms. Strom, was Sargent County open that day? February 13, I can be there at 9:30. Does that work for everyone? Mr. Green?
Did you say February 13th, Judge?
12/13, 9:30.
I need to step out and look at a different computer. This one that I was on died, so I'm on the phone now.
I think you're on vacation, John.
Huh?
I think you're on vacation.
I don't remember which days I leave. I think that's what I was going to look. I'm gone for 10 days there.
Right.
Judge, I leave on the 6th and I return on the 15th.
All right, let's try to find another day. The issue that I run into with these ex parte motions is that the statute or the rule says that the motion has to be heard within 30 days, absent good cause, and the moving party needs to file and serve all of their documents at least 21 days before the hearing. So that really gives us a 7-day window to hold the hearing, which is at least 21 and no more than 30 unless the parties agree to waive that requirement. So, Mr. Green, you're gone almost the entirety of that window. Ms. Strom, do we have other dates?
What's the date you're gone, John?
I'm gone in 6th through the 15th. Monday the 16th when I'm returning, or I'm back on the 15th. So the 16th I'd be available.
So the other dates that the court has available, March 13, March 17, March 18.
March 13, March 17, and March
18.
I'm open on all three.
March 17 would work for me. I have something on the 18th. 13th would work, but I don't work for you, John. So the 17th.
13th and all 3 dates work for me.
All three.
You said March, right?
Yeah.
Yeah.
March.
So, I mean, we could do that. This would be, is this in Foreman? Yeah.
This is in Foreman.
Do you want to, can we, well, okay. Because nobody lives there anymore.
I understand that, but I'm hearing this case in person when we're taking testimony. So.
Okay, in Foreman.
That's where we'll be.
All right. Should we do the 17? No, let's do the 13. Let's do the 13.
Either one works.
Okay.
Ms. Strom is reluctantly saying the 13th will work. The 17th is better. Do the 4 days matter to either of you?
No.
No.
All right. So we will hear all of the pending motions that are before the court right now. And the way I view it, I think there are 3 pending motions: the motion to clarify and amend, the motion for contempt, and the interim order, permanent interim order motion hearing. We'll do all 3 of those March 17. And let's start at 9 o'clock. I said 9:30 before, but I'm going to give the parties as much time as possible. We'll start at 9 o'clock and we'll go until we're done.
Judge,
Yes.
I have a motion to amend judgment that I was planning on filing, I think today. Can we hear that at the same time then?
And I have one too as well. A motion for contempt. So,
Well, get it filed today. And my goal is to have basically an omnibus motion hearing where we take up all the stuff. We're going to have to bifurcate evidence as it applies to the interim order and everything else, because the interim order under Rule 8.2 requires testimony to be received by way of declaration. subject to cross-examination, but obviously for contempt purposes and the motion to amend, that's different. So we'll
Judge, go ahead.
take up the interim issue first, and then we'll take up the motion to amend and all of the other motions thereafter as soon as they can be heard.
And just so the court, there's no way I'd be able to file my motion by the end of today. I'll be able to file it soon, but not today.
Well, both parties are going to be required to comply with the rules of civil procedure.
Okay.
It's the timing of motions.
Okay.
With the availability to respond. So under 3.2 and under the rules of civil procedure, you have the ability to file those motions, but just know that the hearing dates for all of them is going to be heard on March 17 at 9. And so if the motion is untimely, it won't be considered and it probably will end up becoming moot. So get them in within that time frame so I can hear them all.
Okay.
Okay, thank you, Judge.
All right. So now turning to the instant issue. In this case, Rule 8.2A1 affords the court the authority to enter an interim order on an ex parte basis if the court finds exceptional circumstances. The law defines exceptional circumstances under Rule 8.2A1A as a threat of imminent danger to any party or minor child of the party. The court finds that there is no threat of imminent danger to any party or a minor child of the party. As the court explained when it was questioning Mr. Johnson, the types of things that fall within that category in my mind are things such as physical or sexual abuse of a child that has with it immediate and irreparable consequences for the child. I don't see the allegations here as constituting a threat of imminent danger to any party or a minor child. If it was a different type of allegation, the court might have a different view on it. But taking a vacation, which results in the children being out of school and having that impact the children's school, their extracurricular activities, and the parental rights of the other party on a temporary basis, I don't see falling within that category. So I don't grant an ex parte interim order under the authority under 8.2A1A. The issue with respect to 8.2A1B is a much closer call. I'm frankly troubled by Andrew Witosik's interpretation of the judgment and his response to the court's order granting a continuance of the motion hearing. I frankly find that troubling.
So he won, but the judge is not happy about it.
Because the way in which the proceedings played out, Mr. Witasek knew, at least from sometime in 2024, that Miss Witasek did not agree with taking the children out of school for an extended period of time for a vacation. And she can choose not to agree to that extended vacation. I don't read the judgment in such a way that it requires her to consent. And I do believe that Mr. Green's interpretation of that provision at least carries enough weight that it is plausible that that was the party's intent when they stipulated to it. Frankly, the court has concerns that there are many provisions in this judgment that are unenforceable. And part of the issue with this judgment is the parties specifically negotiated and agreed on what it means. And now they're fighting over what it means. Judge Cruft didn't draft this document. The parties did. The parties agreed to it. They negotiated it. They failed to have the foresight to realize that these might be issues. And then they failed, and I say they, meaning both parties, failed to take appropriate action in a timely manner to address these issues, to avoid them from happening in the future. And so when I granted the order to continue over objection from Mr. Johnson didn't present that motion to amend as an emergency motion or a motion for ex parte interim order. and waited in such a way that by filing it December 11, 2025, with travel plans for January 15, it didn't really give the court enough time to consider the issue. It didn't really afford Ms. Watasek an opportunity to respond appropriately or for that mediation process to play out, whether that be through an official mediator or through a qualified third-party neutral. Clearly, the parties know that they don't agree on this trip. That's not new. That's a long-standing dispute since at least sometime in 2024. It's been brought to a head now with this motion. The argument was that time is of the essence because of these travel plans. So by implication, Mr. Watasek knew that he didn't have consent or authority to take the child or the children to Hawaii. The court is further troubled by the effort to change the day during the midweek visitation from Thursday to Wednesday, and then the next day take the children out of school, knowing that he had no consent from Ms. Watasek, knowing that she did not agree, and knowing that the court had not ruled on the issue. It's hard for the court to imagine that being an accident. That to me looks like quite intentional behavior. The question is whether or not that behavior, taking the children out of school, 12 days, knowing that there's compulsory education requirements for children of the ages of the parties' children, knowing, and again, I've received conflicting evidence on whether or not there's harm to the children as a result. It's not just school, though. It was school, it was religious classes, it was dance, it was basketball. It was how it affects the other party. There were lots of allegations back and forth and contested allegations. That's exactly why the court has contested evidentiary hearings, is so those evidentiary records can be fleshed out and developed and the court can make adequate and appropriate findings. Here, Mr. Watasek unilaterally decided that no matter what happened, he was taking the kids to Hawaii. And he did. He left with the children knowing that it wasn't approved. Question is whether or not those circumstances indicate that an ex parte interim order is necessary to protect the parties or the minor children of the parties. It doesn't apply with respect to the marital estate. In A and B, those two exceptional circumstances are, in this court's view, mutually exclusive when they're combined with a disjunctive conjunction, the word or. So the way I read it, B is separate from allegations under A. The court already found A doesn't apply. The question is whether B applies. And so the real gist is whether or not an order is necessary to protect the parties or the minor children. Here, Ms. Watasek has alternative remedies with respect to her parental rights, which include things like a finding of contempt or things like compensatory parenting time. So I don't find that the ex parte interim order is necessary to protect Ms. Watasek. She has alternative remedies. The question is whether or not it is necessary to protect the minor children of the parties for the court to grant an ex parte order. So my focus is on whether it's necessary to protect the kids.
No wonder these two attorneys are so emotionally divested into this case. Can you imagine how much money they're making off of these two?
And again, I think this is a much closer call than Mr. Johnson wants to admit, because I think there is evidence before the court that children being away from school for that period of time causes children harm. I think it's a matter of common knowledge for anyone that has school children that COVID and remote learning is not the same as in-person learning, that it's harmed reading scores, math scores, and the like. I think that's common knowledge within this jurisdiction. I think that's common knowledge across the country that our children, not these children, but our children in general, the United States children, have been harmed when they were forced as a result of a pandemic to remote learn, It is not the functional equivalent. That learning environment is substantially interfered by remote learning or extended absences from school. I think that policy is reflected in the state's compulsory education statutes. Mr. Johnson referred to a number of emails and letters from principals and teachers that the court doesn't have in the record. And I understand why they're not in the record. But even if they were filed, those are the types of things that I would like to have testimony on. And I don't have the testimony, or declarations on, and I don't have the declarations either. So I don't consider those to be evidence before the court. Similarly, I don't have evidence to the contrary that it does harm the kids, other than mere conclusory allegations that being away from school will negatively affect the children. I do have testimony by way of declaration from Ms. Witasick that the children might not be able to be confirmed because they've missed religious classes. I find that credible. I think that's reasonable. If the children aren't there for religious classes to be confirmed, that they won't be confirmed. I don't know if whether or not missing 2 classes or 3 classes is enough. I don't know that for sure, but Ms. Witasick said so. That's a rather conclusory allegation. In terms of time away from basketball or dance, the court does have exhibits where the dance issue is contested, whether or not the children actually have dance in light of the dance instructors' issues. In terms of basketball, I don't recall seeing much discussion of missed basketball other than just knowing that a child away from those activities isn't receiving the same benefits of practice and games and the like. The question is whether or not going to Hawaii constitutes some danger requiring a necessary order to protect the children. I don't think that that burden has been met. So I'm not going to issue an ex parte interim order. However, that doesn't mean that I won't hear all the evidence in a contested interim hearing, which the court will hold on March 17, 2026, starting at 9 a.m. Again, the parties are required to file and comply with all of the rule and technical requirements of Rule 8.2, Rule 3.2, and the rules of civil procedure. Ultimately, we'll address other issues in terms of the consequences or potential consequences for Mr. Witasick's actions at that contempt hearing. And it sounds like there's going to be other competing motions to amend, clarify, modify, or the like that we're going to have to take up. So this is a close call, but again, I don't think it's the type of harm. The burden has quite been met to establish that it is necessary to protect the parties. It might be beneficial to protect the parties or the children, but I don't know if I can find with the certainty I'm required to find it by a preponderance of the evidence that it is necessary to protect the minor children by issuing an ex parte interim order. Nevertheless, I'm not happy with how the parties have behaved, and we're going to take that up when we get there. Mr. Green, do you understand the court's order and its reasoning?
Yes, Your Honor. Yes, Your Honor.
Any questions?
No, Your Honor.
Mr. Johnson, do you have any questions about the court's order?
No, Judge.
All right. Anything else that we need to take up from either party?
No, Your Honor.
No, Your Honor.
Mr. Johnson, I'll have you prepare a brief order that just says, for the reasons stated on the record, the ex parte motion is denied.
Okay.
Anything else?
No, thank you, Your Honor.
No, thanks, Judge.
With that, we're adjourned. Have a good day.
Oh, thank you.
Mr. Johnson submitting a brief order? Clearly, you haven't been listening the past 2 hours, Your Honor. Oh, I have a feeling that in-person hearing is going to be a spicy one. I don't know if they'll air it. I don't know if it'll be live streamed. I'm going to look. I'm going to see. I have never heard that courtroom mentioned before, though. I can't even remember the town that he asked if it was in, or county. But We'll see. We'll see. If I can get it, I'll get it. I just found that one interesting. Oh, that's what I become after my meds. All right, guys. I guess I'm gonna go back to exactly what I was doing prior to this. Finding cases and streaming with you guys. I need to figure out a way of getting Ava outside though. I will wait until she's asking. I feel so bad for her. But even if I was to put puppy pads down or something like that, she wouldn't use them. Which I'm grateful for. But on the same token, it's like it's really cold. Oh no. Tricker. That is not nice. That is not nice. It's too cold. Thank you for being here, Patrick B. Hopefully I'll get to see you tonight too. Ooh. Nap sounds fun. Oh. See, normally I get frustrated like when there's a lot of snow. She'll start heading down the ramp and she just squats and pees, and it's like, that's not the yard, you know. I mean, she doesn't know any better when there's, 5-6 inches, whatever. But I couldn't get mad at her if she did that. I wouldn't get mad at her if she did that right now, like right on the deck. I'll clean it up later. She can't be outside any longer than a regular kid could. It's not fair. Well, oh, the solar powered one? Turns out, doesn't work so well in Wisconsin. It's too cloudy. There's not enough sky coverage, I guess. I thought that it was such a great idea, but when it's overcast, like on the really cold days, how it always is. I know, that's why I don't get mad at her. It's annoying and frustrating, but when there's 4 or 5 inches of snow and she does it, oh well, it's gonna get shoveled off. Poops are flying. All right, guys, I love you all so much, and thank you for being here. Hopefully I'll be back on tonight. I will try. I will try. Be safe, be well, stay sweet, and much love.